Item number 1. Item number 1.
This old matter, this about 20-year-old matter was posted yesterday. Counsel for the petitioner was absent. To give one more opportunity, it is the following order was made, and accordingly it is posted today. First, counsel is again absent. This raises a presumption that the matter itself has become infructuous. First one. Next one. In view of the above, petition is disposed of as having become infructuous, with liberty to the petitioner to seek revival of the matter in the event it still survives. Registry to send a copy of this order to the learned civil judge. Go to the prayer. Learned civil judge senior division, Bonai. Is it Bonai? Bonai. For his wife. If LC or teacher come up, the same should be sent back in a lightning speed to the court below. Next.
Item 2.
May please.
Yes.
Well, I'm told my wakalatnama was scanned and e-filed, but physical copy for some reason is pending.
Beg your pardon. I'm appearing on behalf of the petitioner. The learned senior counsel is supposed to argue, but due to be revealed this family.
What has happened is that the petitioner,
Seeking a short attorney.
the petitioner, my lord, the original petitioner when the petition was filed in 2004, LRs are brought on record. And there are, my lords, now about 8 petitioners, my lord. I'm appearing for 1B, or in the cause list, it's cause title is 2.
One of the LRs.
One of the LRs. My learned friend senior is appearing for one of the other petitioners. My lord, matter relates, my lords, to a piece of land measuring about less than half an acre. 0.456 acres.
Who is the opposing party?
The statements.
State is the opposing party.
Let's
Yes.
before my
For admission, it has come.
let's
Yes.
kindly have a glance to my lord's last order dated by lord 16/10/2025. Last order my lord
16/10/25.
lordship. Before my lord's
The lease deed had to be filed. I'm told it's filed, my lord. The typed copy of
Copy is filed.
Copy is filed.
Compliance is done.
And they have not served the copy, my lord.
Let us see what is the matter about. Like, it's in admission, no?
Does not.
After notice, it has come. No.
Matter, my lord's notice was ordered. The matter has been heard on a number of occasions. It's a 2004 matter, my lords.
2004 matter.
My lords.
Yes.
That is the priority list, 20 years priority list.
Huh?
20 years priority list, my lord.
They are not clear.
My lord, 20 years priority list, my lord.
Priority list.
Lordship.
Okay. So no date can be given because of apex court judgment. No adjournment can be given.
Lordship.
Yes, brother.
Yes. No, the type copy on the last photo.
This is also
My lords, if your lordships look at annexure 1 at page 27.
What is the matter? Can you make the statement? I made this statement.
The petitioner, when the 2004 petition was filed, was one Mr. Basudev Agarwala. He, in 1966, had applied for 1 acre of land in the city of Bhubaneswar.
For allotment.
For allotment.
1966.
1966. He applied for about 1 acre of land.
Yes.
He was allotted merely half acre of land in 1967.
67.
The lease deed that my learned friend appearing for the state was referring to is at Annexure A. It has been produced, type copy is also produced. There was some handwritten element, but anyway, that lease deed is not relevant to the present lease. When he started developing the half acre of land, he realized that it is a low-lying area. It is swampy in nature. It is prone to flooding. For the purposes of the construction,
It was allotted for what purpose?
he was allotted for commercial purpose. There was a steel rolling mill that was initially proposed to be put up. Thereafter, that was amended to a petrol bunk, and a petrol bunk was put up. Go down stores, etc. were put up. So it was for industrial and commercial purpose. Over a period of time, the use has changed.
Whether that user is changed with the permission of the
Yes.
allotter?
Yes, yes, yes.
Yes.
Now, what happens is that per force, owing to the vagaries of nature, the swampy nature of the land, prone to flooding, when I'm putting up construction, I am per force constrained to use the adjacent land.
Not belonging
Not allotted to-
nor allotted to you.
Not allotted. The first thing I do is I go and make a disclosure to the government that I have per force been constrained to use the adjacent land. I have made an application for of land. I was allotted only half an acre. Due to vagaries of nature, I am using additional land. Kindly allot it to me. Kindly tell me what premium, what cost, what rent I have to pay. I will comply. I don't receive a response despite numerous communications. In 1972, I am given a letter saying that a decision has been taken to allot the additional land to you on payment of premium and penalty up to 10 times that premium. Penalty of up to a penalty of 10 times that premium is proposed to be extracted from me. I make a representation saying
What is that premium? Is it a cost of the land? Or
it feeds to the cost of the land. There is one component which is the cost of the land. Two, there is the because it is centrally located in the city of Bhubaneswar, I am asked to pay a premium, and thereafter I am asked to pay a penalty, possibly on the ground that I have already encroached. What happens, my lords, is that I say, look, this 10 times seems to be onerous. There does not seem to be any policy, law, or rationale to justify 10 times. Kindly give me a more rational number. And I keep feeding a number of reminders saying I'm ready to pay, ready to pay. Please pay. Please
reduce the rate of premium.
reduce the rate of the premium. Give me the final proposal. I will comply immediately. Matters stand thus for over 2 decades. In the 1990s, my lease deed for the first parcel of land is determined or terminated on the basis that I have not complied with certain conditions of the lease and that I am an encroacher so far as the rear portion of the land, the additional land that I am seeking, I am an encroacher. I come to this honorable court and I say that I may technically be an encroacher because I am using land that does not belong to me.
Why technically? You are.
I am. Hey, under law, I am an encroacher. But I have 2 submissions. One, I have done so in full transparency. I have made the disclosure. I am willing to pay. And 2, this has been going on since 1969. How are you terminating me in 1996 for illusory reasons?
Termination is on what ground?
Termination
Lease was for what period?
The lease, my lords, is for about 99 years.
The lease comes sale.
Yes,
Lease comes.
it is, the lease is about 99 years. So therefore, my lords, I am, for all practical purposes, until about 2069, I am the lessee. That termination, my lords, is challenged before this honorable court. A division bench of this honorable court sets it aside. The division bench also takes note of the fact, the state's argument that I am in encroachment, and says that no, given the longevity of the encroachment and the statement made by the petitioner that he is willing to pay the premium and penalty, there is no purpose served and it is not in public interest to evict him. Division bench of this honorable court says so.
Recorded such a finding.
Yes, I will take your lordships. SLP against that order, my lords, the judgment and order is dismissed. In course of the hearing before the division bench of this honorable court, the state gives a proposal, a calculation, giving the rate of premium that is extant and extracting and proposing one-time penalty. If the premium is 100 rupees,
Instead of 10.
instead of 10. But they do so, the calculation that is given is on about 1956 square feet of land, which is again part of the encroachment, but they come up with the calculation only for 1956 square feet.
It's only the 1956 square feet alone is allotted to you.
The calculation was
You
submitted?
said
Yes.
1970, no, 1972. You said the additional land which you had encroached was allotted.
Was decided to be allotted, subject to payment of 10 times payment.
No, that I have
Yes.
understood. What is the extent of land?
That is 0.456 acres, 0.45, nearly about half an acre, about 20,000 square feet. 20. So, my lords, what happens is that when that an amendment lease deed, a supplementary lease deed with respect to the 1956, less than 2,000 square feet of land is entered into, the extent of land that is originally allotted to me, the amendment is brought, and both the pieces of land are contiguous. The lease deed is now for the original half acre plus about 1956 square feet. I write to the state again, saying that as per my submissions before the Hon'Ble High Court and the finding of the Hon'Ble High Court that it is not in public interest to evict me, and your submission that you will now extract one-time penalty by way of one-time the premium by way of penalty, I am willing to pay. Please give me the exact amount. I will pay it. This is, my lord, in 2003 the matter is disposed of. In 2003 and 2004 I start writing. After the SLP is also dismissed, I start writing.
Yeah.
There is no response whatsoever, my lords. There is no response whatsoever to the my repeated entreaties, my repeated requests. What happens instead, my lord, is that physical inspection starts taking place and I feel the threat of dispossession. And I'm constrained to come to this honorable court again with this writ petition. This writ petition is filed in 2004.
That is in respect of 1956 square feet.
1956 amended lease deed has been executed. There is no dispute with respect to 1956 square feet. With respect to this additional 0.56 acres, additional about half acre, I am constrained to come to this honorable court because there is non-implementation of the ratio of the original judgment of the division bench of this one, and there is no response to the repeated entreaties that are made, representations and entreaties that are made.
But having entered into the subsequent lease,
My lords,
will it not amount to giving up your right in respect of the land beyond 1956 square feet?
my lords, contemporaneously I have made representations saying that I'm not in encroachment for the entire portion. I'm willing to pay for the entire portion. There is absolutely no waiver or giving up of right now. In fact, one of the arguments is that there is constructive res judicata. In fact, my respectful submission is there is actual res judicata in my favor. The court has held that although it is, but I'm willing to pay, I'm not. It is not in public interest to evict me. And therefore, my lords, in 2006, after I come to this honorable court, notice on admission is issued, matter is pending.
Any interim order was granted?
To my knowledge, not. My lord, I have been able to take a look at the order sheet of this honorable court. There doesn't seem to be an interim order subsisting. In 2006, my lord, then this is important, and a proceeding under the Orissa Public Premises Eviction Act is initiated.
What happened to that?
Yes, that is yes. I file my objections to that proceeding, the notice that I received. I also file an interlocutory application, which is listed as a miscellaneous case before this honorable court, saying that, look, there is threat of eviction. I deserve protection of this honorable court. Notice on that also is issued. What happens is that in about August 2006, the competent officer under the OPP says that he has not, after I file my objections, he has not heard back from the land officer, and therefore those proceedings for eviction are abandoned. In 2006, those proceedings are said to be suspended without those proceedings are abandoned.
Any abandoned means any order for abandonment?
Yes,
must. Dropping the proceedings?
Yes, ma'am. Yes, ma'am. It is unfortunately not on record. I'm just filing a memo with a copy of the order.
Please serve copy on the other side.
Please, of course. My duty.
So OPP proceedings came to be dropped.
Yes, ma'am.
But 1 second. If OPP proceedings are dropped, your occupation does not become regular.
It does not. It does
Continue to be a trespasser.
I continue to be a trespasser. I am seeking parity so far as the 0.456 acres of land are concerned and the 1956 land of concern. As an implementation of state policy, my plea is that state has to be consistent. Having acted in a particular manner, having stood by since 1969 when I have first time disclosed my trespass, I am entitled to consistency in policy, not just with regard to my user of the land, but also with regard to the premium that I have not paid. These are my twin contentions.
Your first proposition is?
My first proposition is,
Please give a dictation to my question.
madams, by virtue of long and undisturbed possession of the subject land, which was disclosed to the state in 1969, and the express statement of the state government in 1972 that a decision has been taken to allot the land to me, petitioner is entitled to continue in possession of the land and regularization of his trespass by paying appropriate premium in accordance with law. 2, the state, in light of the state's submission in the previous writ petition before this honorable court, the state is stopped from applying a different standard to the remaining 4.56 acres, 0.456 acres of land.
Is it estoppel or restituted?
Both.
After all, the adjudicator is also a cousin of estoppel.
Yes, the estoppel arises when they when they give instructions, when the government gives instructions to learned government advocate. Res judicata arises when the finding of the court is recorded.
Well put.
So I am on both. The memo that I have just handed to you.
The text of your additional lease. If the lease gives an impression that you have given up, this additional lease is entered into post-DB judgment.
Please, ma'am.
Please, therefore, let us see. Then the question of estoppel and res judicata may wither away in thin air.
Additional lease.
How the text of
I will just.
first in that additional lease, have you stated, I have been in occupation of 400 or you have said I am in occupation of only the land now allotted to you.
My lords, the additional lease, my lord, as your lordships would appreciate, is very often a typed form that is given to me by the respondent, and
that may not come to you because you are not an or person from rural background or scheduled caste, scheduled tribe, oppressed community. That is not the case. You are not a pagan. You are an industrialist. It's a company. Whether industry is a company. Company is running the industry or individually is running the industry.
Individual.
What is his qualification, client's qualification? What is he standing in the life?
So far as the original petitioner was concerned, he was one of the early entrepreneurs who had come to the city of Bhubaneswar and set up industry and had improved the land and had contributed to the society. The petitioners before your lordships today are his legal heirs, his descendants.
No, what are they? What is their standing?
They are persons engaged in commerce and industry. Their formal qualifications, my lord, I'll tender across.
Therefore, it is not that some backward people before the court.
That is
Then let us see. Because Apex Court said in 1952, while adjudging the terms of the conveyances, the standing of the parties to the conveyances should be looked into. How that is tested? Have you said that we have encroached X land? We are being given lease of X minus Y land. Is it the way that lease is texted?
The lease deed is available at page number 50 of the petition.
Not original. The additional.
Edit, supplement.
50.
50.
This is a supplementary lease, not additional lease.
Supplementary.
If it is a supplementary lease, it becomes part of the first lease.
That's precisely what it is. That is precisely what it is.
How it is tested? Where have you stated your occupation?
Your lordships come to page 54. Whereas this lease is supplemented to the deed of lease dated so and so, made between the parties. And whereas the parties agreed that the plot of land demised to lessee under the principal lease deed number so and so be increased due to availability of 1965 square feet of government land. As such, the measure of the same should be
1965.
Yes.
Square feet.
Yes.
This is available.
This is the lease deed says due to availability.
Available. That means the rest of the land is not available. Then I'm just saying something against you.
I will come over. I will overcome
that.
I will overcome that. And as such, the measure of the same should be increased to 23,745 square feet instead of 21,700
under the original lease.
So plot is increased from 21,780 as originally demised on condition that the lessee pays the additional premium and agreed to pay the additional rent proportionate to the increase in the demised hereby. Now this deed witnesses as follows. In consideration of the lessee having paid 4 lakh to be paid as additional premium and additional rent of 11 rupees 25 paisa payable each year, the lessor hereby demised to the lessee the increased area stated about and specified in the schedule here, attached subject to the adherence of all terms and covenants contained in the principal deed in respect of the original grant for the unexpired term thereof. The lease of the land allotted as above shall be for the period of 90 years.
Where is the allotment letter?
The lease, my lord, is an annexure.
Did you object to allotment letter? See, I have been occupying so much of land, but you are allotting me only short piece of land. I am not happy with that. You should give full allotment in terms of the finding recorded by the division bench.
That is, in fact, my cause of action. Numerous representations are made exactly to that effect.
Now, thereafter, this lease has come.
After the litigation, this lease has come. In parallel, I have representations to the state government saying that I have been in use and occupation since 1969 of this 1965 plus 0.456 acres.
What is the extent of the layout?
If your lordships are pleased to see page 68, I will also take your lordships through the memo that I have just filed because that has the translated copy of the proceedings under the OPP Act.
No, that OPP Act, Rajasthan High Court has said under the Rajasthan Public Premises Property Eviction Act, merely because the proceedings have been dropped or otherwise abandoned, the occupation does not become regularized.
It does not. It does not. I am standing.
Lessor is the owner.
Yes.
You are in unauthorized occupation of the land.
Yes.
And you sought for that.
I'm saying
Division bench said, I don't know why division bench said like that. Anyway, division bench rightly, wrongly said that way.
Right.
It may operate a kind of estoppel, or at least res judicata also it may operate as.
Right.
But question is, by subsequent acts, if res judicata dilutes, even estoppel dilutes, where is the cause of action for? Now, you did not say, I am entering into this lease, reserving right to fight for rest of the land.
That does not seem to be on record. Ma'am.
It is not there.
If I'm able to find something of that sort, I will produce it before this honorable court. On page number 68, my lords.
68.
Yes, there is a sketch.
Yes.
On the, if your lordships are pleased to see, there is a square with the number 657 that is written over there.
No,
So-
on that, all that, no
Yes.
dispute at all.
Yes,
You are given X property by way of lease decades ago. You encroached Y portion of the land
yes,
belonging to the lessor.
yes,
Then there is some litigation. Your first lease itself was set aside. That came to be quashed by the division bench.
yes.
Challenged before the apex court failed. Division bench observed, when already he is in another occupation of the property, a decision has to be taken for how that is structured. Let us see.
Yes, precisely. Judgment page. Your lordships will find the judgment of division bench of this honorable court at page number 37.
There is a famous book by an English author, I forgot his name. Res judicata, estoppel, and waiver. Very famous book. Somehow my memory is playing trick with me nowadays. One of the best books on that aspect. Res judicata, estoppel, and waiver. Anyway, yes.
Your lordships may kindly come to page 37. The judgment starts at 37. The cause title is at 37. The judgment starts at 38.
Where is the finding?
Yes, ma'am.
The other aspect is,
My lords.
this is only metaphorically I am saying. Suppose if a robber, the robbery can be, Macaulay said, robbery is in respect of movable property. For immobile property, he did not use that one. That he used it as criminal trespass. The pheasants of that idea. I am the owner of the property.
My lords.
You are holding a piece of my land. And maybe for XYZ reasons, you start using my other piece of land unauthorized. And you seek a
Yes.
of the ground is, I have robbed your land. Therefore, grant me. Yes, sir. Conscionability aspects which writ court should look into also will arise.
Please.
But one protection is division bench has already put this.
Yes. Besides, what happens, my lord, is that the state is holding the land as trustee for all of us.
All of us.
Now, I am one of the beneficiaries.
Hugo Cracius statement that belongs to none, belongs to all, that belongs to all, belongs to none.
Correct.
It is holding it in trust, public trust
For all of us.
for all of you. But you want to monopolize it. Suppose if the state wants to give it to rest of the entrepreneurs, how can you say that it should not? I am the encroacher, the robber. Therefore, my claim should be preferred.
It had 55 years to do so. It does not do so. It communicates a decision to me that it is decided to be settled in your favor. In 1972, he communicates a decision to me that it is decided to be settled in my favor.
Extent.
Yes.
Extent.
The 0.456 acres, the entire extent of my trespass, decided to be settled. The only question is, what is the premium that I have to pay? In 1996, I come to this honorable court. In 2003, when the matter is being disposed, he brings the calculation only for the 1956 square feet, 1965 square feet.
You should have said, why 1956 square feet?
Yes, I should have.
You write entire that one. And you
should have.
signed with open eyes. You signed it. You are an entrepreneur. You are an industrialist. How you are going to overcome that one? But let us ask them also. Any other points which you want to say? These are the two propositions.
These are two propositions, my lord. The memo that I have.
I'm sorry. I interrupted you. I wanted to read the observation.
I wanted to read
the bench. Just read that.
If your lordships are kind enough to take page number 43. I can take your lordships through the entire judgment, but from page number 43.
Relevant portion.
Yes.
If you want to read entire judgment, I can read also, no issue. But relevant portion, because you have already articulated your proposition.
41, my lords, there are, what is extracted is undisputed facts, paragraph 4. Therefore, I'll just take your lordship through 41.
Following undisputed facts, how much?
Yes. On an application dated 15/12/1966, the petitioner was allotted plot number 25A, measuring half an acre of land in the industrial site at Karavela Nagar, Unit 3, Bhubaneswar, for industrial purpose as per order of the state government mentioned in memo number 1409 dated 22/2/1967. Lease deed was duly executed between the government of Orissa and the petitioner on 25/2/1967. It was registered on 21/3/1967. It was mentioned in clause 1 of the lease deed that the demised premises would be used for rolling mill. He encroached upon 5.534 acre of government land and constructed structures, better building unauthorizedly. Although the leasehold area was originally in the industrial zone, it was later declared to be within the commercial zone. On the request made by the petitioner in his application dated so-and-so, government on 8/2/1969 decided to allot an area measuring 1965 square feet, 9 feet by 145 feet and 10 feet by 6 feet to the east of the plot number 25A, on which the petitioner built a pakka building and structure unauthorizedly on payment of premium of rupees 11,277 for the said area by 22/1969. As he did not deposit the amount within this time, he was given another opportunity in letter number so-and-so to deposit the above amount of so-and-so by 25/12/1969, subject to the condition that he would also remove encroachment from another 62 feet by 145 feet without further extending his encroachment. On consideration of the application dated so-and-so, government gave another chance to the petitioner by letter dated letter number so-and-so dated 27/4/1972 to take on lease the backside portion encroached land on payment of penalty rate 10 times the normal premium in accordance with the policy of the government for leasing out encroached land. The petitioner did not avail the opportunity. Thereafter, he was asked to show cause as to why the lease should not be determined, and ultimately by impugned order communicated Annex 13, lease was determined. Shri so-and-so learned counsel for the petitioner. The arguments are recorded. Your lordships may kindly come to page 43 at para 6.
Whether there is any clause in your earliest lease, the first original lease, that you shall not encroach any other land. Is there such a clause?
I just. Doesn't appear to.
Yes.
Doesn't appear.
Does not appear because that is the law.
Please.
Nobody should encroach others' lands.
Please.
Yeah. Yes.
Your lordships have page number 43. I was at paragraph number 6.
Yeah.
Let us now come to the core of the.
I read that
Yes.
paragraph. Just
Yes.
go to the next paragraph.
Yes. From the above, it may be seen that the petitioner was alleged to have violated 5 subclauses of the clause 2 of this lease deed. On reading of the aforesaid clauses of the lease deed, the illegal action alleged to have been held by the petitioner does not follow as a necessary corollary. Clause 2(3) of the lease deed lays down that the petitioner as lessee shall pay all rates, taxes, and charges payable in respect to the demised premises or building to be erected thereon. It is not the case of the state government, as is evident from the impugned decision, that the petitioner defaulted in any of the rate, tax, and charge payment in respect to the demised premises, being so and so, or buildings constructed thereon. In fact, my lord, my instructions are that even today on the encroached portion of land, the tax that is being collected includes the building.
No, collection of tax is by the local body.
Yes.
It's another thing. It is like levying tax even on the robbed money. Illegally gotten money suffers income tax.
At what point in time does it translate to acquiescence will be my submission.
That's it.
Yes, well. Clause 4 states that the petitioner shall at his own expense and with the previous permission of the government in writing, erect upon the lease structures to the satisfaction of the government authorities. It is also not the case of the state government that the petitioner erected upon the leasehold land any structure contrary or in disobedience of the competent authority. Clause 5 provides that the petitioner shall not erect or build on this demised premises any building other than that in a plan specified approved by the state government, nor make any addition to the existing building except with the written approval of the lessor. From the government decision, it may be seen that it is not the objection of the state government that the petitioner on demised land constructed any building without any plan being approved by the competent authority. Clause 6 of the lease deed binds the petitioner that it shall conform to all rules, notification, bylaws of the NAC Bhubaneswar or any such local authority relating to them. It is not the case of the government that the petitioner has done anything contrary.
Mr. Brother,
Yes, ma'am.
come to internal phase 48.
Yes.
Having regard to the prevailing premium of the land for commercial purpose, 75 lakhs per acre, we direct the state government to settle encroached land, that is 1965 square feet.
Madam.
So your res judicata is confined to 1965 feet only, nothing beyond. The court says, division benches say,
Yes. Your lordship may then see the affidavit that I filed, which is extracted in paragraph 8
in the present paper.
in the judgment note at page 46.
Your affidavit.
Yes, it is extracted in internal page 9.
How that going to come to your aid? After looking into that affidavit, the finding has been recorded by the court.
That is because the government, my lord, comes with a calculation only for 1965.
You should have said, no, you should, I am not agreeable with 19. You did not challenge this.
I did not challenge it. I am seeking implementation of the ratio of this.
Ratio, finding.
Fine. The basis on which, please, my lord.
The rest of the things, para 8 is the, no, that go to the last paragraph. Don't change paragraph when I am reading. Okay.
My apologies.
No, not you, our people. They change paragraphs when I read.
Starting from para 9 minute.
Para 9. 9, you are right.
The relevant portion is page 48 of the judgment.
Your affidavit, you want me to read?
Please, my lord. Extracted at para 8, internal page 9. Lordship, sir.
Right.
My affidavit, therefore, my lord, before this honorable court is both with respect to the encroachment where the decision is made in 1969 and 1972. The letter at 1972, my lords, I will take your lordships through. And I have made an offer that I would pay premium with respect to both And I submit that it is my understanding that the penalty is one time the premium and I will pay with respect to both.
No, that was the stand you had.
That is the stand acting.
Battle lines were drawn up. Battle
Yes.
lines were drawn up.
Drawn. Yes.
But what happened to the outcome of the battle is in para 9.
Yes.
Para 9 says you are entitled.
Before para 9, my lords, there is a finding because the extraction of the instructions to the government advocate end at subparagraph 3 on internal page 10.
Premium of the encroached land.
Yes, that is
1965.
Kindly see, my lord, the next paragraph, which is a finding of the court. Encroachments were made by the petitioner more than 3 decades ago. He has also made certain constructions thereon. In the meanwhile, the area in question has changed to commercial zone from industrial zone. Therefore, at this length of time, eviction of the petitioner from the demise plot, as well as from the encroached area, is not in public interest.
Encroached area means the court has recorded what is the encroached area. In affidavit, you said you have encroached 5,000 acres of land, but court said it is 500 meters.
Well,
The other portions, how we make the decision, Dobbelly in Art of Thinking clearly says, he analyzes how judgments are made, decisions are made.
yes,
Reasoning part is one, outcome is another. There's a famous book
Yes.
by Dobbelly's Art of Thinking
Yes.
clearly. He says, all reasoning part propels to the operative portion. If one decides to marry one lady or one girl or one boy, these are the factors. How he looks, how is his hair, how is his ear, how is his nose, how are his lips. All these things together, it leads to decision
madams,
to marry or not to.
madams.
That way, the reasoning is found in the body of the judge.
Yes,
But the operative portion of the order binds the parties rightly or wrongly because of res judicata.
madams. May I persuade your lordships to read paragraph 9, which my learned friend was also requesting.
Yeah.
And then the relevance of my affidavit becomes clearer. In view of the fact that the state government at a particular point in time decided to regularize the encroachment by settling the same with the petitioner on payment of premium and penalty, we are inclined to hold that for the ends of justice, the said decision of the government should be resuscitated when the petitioner is now agreeable to pay the premium and penalty, as stated in his affidavit dated 21/8/2002, the Joint Secretary of the Government in the letter dated so-and-so has indicated the premium of, this is on the basis of the letter that the Joint Secretary sends. He gives a calculation only, whereas the previous portion records my undertaking with respect to the entire encroached land. It then moves to the letter of the Joint Secretary preferring a calculation.
No, even paragraph 9 also mentions 1965 square feet. Had it not been mentioned, arguably you had a case.
Yes, my lord. Now, the paragraph 9 flows from the first part of paragraph 9, which is still at page 10, internal page 10.
You are right. You are right. Only to that. But rights have been, how we are going to interpret the judgment?
Well,
The rules applicable for interpretation of a judgment are different from the rules applicable for construction of a statute. We are encroaching. Now, by and large, if a man, an average man trained in law, not necessarily in chair and armchair, if he reads this gives you. Let us see what they say also. Do you have any other point on?
but these are the
Any rulings you want to?
please. This arises out of service law, my lords, but
What it says?
I am on the proposition of acquiescence.
Acquiescence.
Your Lordships may be kind enough to come straight away to paragraph 35.
25.
In fact.
36.
What is a reasonable, here, my lords, I am in disclosed encroachment since 1969.
Correct.
I am offering to pay the penalty and I'm offering to pay the premium and the penalty, if any, as determined in accordance with law. The state waits until 2006 to commence proceedings under the OPP Act and thereafter abandons them.
What was the stand you had taken up before the OPP?
Yes, I had filed my reply under the in the proceedings under the OPP Act, bringing to this honorable court, bringing to the competent officer's attention. A decision was taken in 1972 to allot the land in my favor, and I'm yet to share your lordships that letter. I will do that. It has been in my possession since that time. I have offered to pay the money, and the judgment of the honorable court in the first writ petition, the findings and the reasoning thereof supports my case that I'm not to be treated, not liable to be evicted, and the land should be regularized and settled in my favor. And that with respect to this remaining land, a second writ petition, which your lordships are now hearing, is pending before the Honorable High Court. This was a detailed reply was filed, and that has been filed by a miscellaneous case in 2006 by an IA before this Honorable Court. I will take your lordships through that. Your lordships have para 36 of this?
Yes, 36 I read. That reasonable time.
Yes, yes.
For what? Reasonable time for what?
In order to dispossess me, because I have spent time, effort, money. I have improved the land. What was now a swamp is habitable.
No, I suppose if the robber takes 2 dollars of my gold.
Yes.
And studs it with diamond.
Yes.
Can he contain? No, I have studied it now.
Yes.
Therefore, you cannot seek restoration.
If he instead says that, look, I was in the shop, I was looking for something, I purchased some gold, some other gold while I was packing what I had purchased has come to me. I have
not that. You have taken the gold.
Yes.
If it had happened, I would have understood.
I have taken the gold. It was lying unclaimed at a particular point in time. I have paid for another piece of gold. I have taken it. First thing I did as soon as I reached home is I called you and told you, look, this additional gold has come to me. Please tell me what is the amount to be settled for it. And he says after 3 years that you have taken the additional gold. There is a policy decision that gold I'm going to draw a bill of sale in your name. Please pay 1 lakh rupees for it. I said, no. The current price is about 10,000 rupees. Please take maybe 20,000 rupees. I am sorry, I have done that. And he keeps silent. Now, suddenly he says that, look, you offered to pay. It is not as if that land is earmarked for anything. Had it been the case that I am obstructing a college from being built, I would have had no face to show before this honorable court. Since 1969 to 2025, he sits silent. Repeatedly, and Manoj, I have been remiss. I have to take your lordship through the communication where I am imploring him, please take the land. The land, rightly or wrongly, because it was a swamp, I had to do something. Water was coming in, some wall has been built. Now, he leads me to an expectation that I will not be dispossessed. That he leads me, he adopts one line of course, 1972, even for this additional half acre, he adopts the same reasoning. But in 2003, he actually implements it for 1965 square feet. What is preventing him? It is not his case that a college is to be built there. It is not his case that I have broken the law in any other manner, that I am refusing to pay. He has to, consistency, in Vodafone, the Supreme Court says that predictability is the hallmark of rule of law. Now, having treated me in a particular manner for one portion of land, how can he treat me differently for another portion of land? I am not running away. What prevented him from in 1970 to dispossess me and say, look, this is land, half acre is required for a secretariat. I will build it there. I would have had no case. Today, when my grandchildren are there,
Let us see what this is.
The lead gas for 1965 square foot mallet.
Original lease was for?
For construction, 1960 square feet mallet.
No, half acre.
Half acre is encroached mallet.
No,
original is half acre.
half acre.
Your Lordships, we kindly take Annexure A.
Dated?
1967, my lords, I'll give the date. 19th of March, 1967. It's at page 20. 4, my lords, Annexure 1.
Encroached area is how much?
For the encroached area, my lords,
Extent?
yes, it is 0.456 acres. That is the subject matter of this list. Previously, an additional 65 square feet was encroached. That has been settled in my favor.
This is in addition to that 90?
Yes. And that is what the previous judgment, my lord, where I say that it is before their lordships that I have in fact encroached another half acre.
Then virtually it amounts to asking the court to place premium on illegality.
No, my lords, I am requesting the court to place premium on consistency.
Because there are many people. Otherwise, see, actually, during British rule, whoever was encroaching, he used to be hanged in Bengal.
My lords.
But here is a person who encroaches land and says that it should be granted to me because I am an encroacher.
Yes, then he should have been hanged in 1969. Then legislation should have made by state amendment to the IPC, encroachment should have been made or by a separate state statute, encroachment should have been a capital punishment penalty, and he should have been hanged in 1969. Having allowed him to
Continue illegality.
Yes, having abandoned the eviction, having not mentioned that it is required for a school, college, nursing home, hostel, having refused to take my money, arbitrarily comes up with a 10 times penalty.
No, but anyway,
Well,
their rights have been concreted by the division bench judgment.
yeah, but
Ended with that.
yes, ma'am. There is a diversion. If your lordships for a minute looks at the division bench judgment again.
Yeah.
Page 30, sir. Yes. At page 37, I just want to point out an aspect. On page number 41, your lordships, internal page 4.
From the pleadings of the party, the following undisputed.
Yes, towards the bottom of that page, 4 or 5 lines. He encroached upon 0.0534 acre of government land. 0.0534 acres.
0.5, about more than half acre.
More than half an acre. From that,
addition to 0.456.
no. This is the entire extent of the encroachment from which 1965 square feet has been regularized.
Because court said 1956.
No, because the court accepts my contention with respect to the entire land. He brings a calculation only for 1956.
But you agreed with that.
I accepted it on the premise that now the court has given a finding in my favor, and therefore the finding and the reasoning of the court will be consistently followed by the state in other action. How am I? And when he does not do it, I come back to this honorable court. That is my recourse.
No, how? Your whole case is how much encroachment you have done, what it should be done to that. Everything is spoken of by the division bench.
Yes.
And that culminated into a fresh lease, a supplementary lease.
Yes.
Then end of the matter. It is.
At that point in time, once the court says that, look, you are entitled to be settled, he says this is the calculation for 1956 square feet because it is in front, that is it's abutting the road. And I accept that with the expectation that he has to follow it for the rest.
Let us see. What is it?
Well, it's the lease deed.
What is the extent of the layout?
I will answer that, but apart from that, he has also
Have your
filed
mic already. Your
he had
voice is
filed-
big and
he had filed a suit before the Lord court below, and that was dismissed for default,
That is,
in the
that's
year
dismissed, my lord, before the division bench. The division bench takes note of that.
no, what is the extent of the layout?
Not, that's it.
What kind of preparation cases are there? What is the extent of the layout? How many people claim this one? Whether one person can seek monopoly on the ground that he has already exposed. These are the aspects of the mine. These are held in trust. And what is the policy under which allotment is made? Where is the research?
He has allotted with land for a rolling mill.
That's all right. Now, what is the policy
Lordship.
of allotment? To whom it should be allotted? What is the policy? Where is the research? Why your government advocates are not up to the mark, barring one or two?
My lords, your lordship, he has not prepared within short span. Your lordship will call after lunch hours.
Possible. You should, I expect performance of the government lawyers much higher than private lawyers. That is the reason you are chosen. Otherwise, state will be unsafe at your hands.
My lords, prima facie the acquiescence and however that is not applicable to a law.
We'll come to that.
My lord.
I am asking, what is the policy of allotment?
I'll assist your lordship
What
after
is
lunch.
the extent available? Call your officer here. In matters like this, especially when senior advocates appear like this, you should bring your lawyers, your briefers. Somebody should brief you. Otherwise, how I should decide the matter?
My lord.
Most of the times, the state is at the receiving end because of the bad performance of government lawyers.
Your lordship. In 2004, my representation, my lord, contemporaneous to the judgment of this honorable court and the 972 decision to allot it, my lord, I'll take your lordships through in reply minutes. Or if my learned friend gives me 5 minutes at 2:30, I can do that. Either.
Very good.
Your lordship.
Now you say that also, so that they will come out with that response.
1970.
You have made a representation in 2004.
But before that, page 101.
Now, my question to you is,
My lords.
if all lands are granted to big people like you, what about the other entrepreneurs?
My lord, is it his case that there is a right?
No. Therefore, I wanted to know the policy of allotment.
Please.
Policy of the allotment, Supreme Court said, where any industrial layout is established.
This is under OGLS Act.
39, Article 39 B and C, distributive justice, not holding of, just read that 39 B and C. The state shall, Article 39, but give that of the Constitution. The state should pursue the policy of distribution of wealth. That's how there are judgments to that effect also.
Provided there is an entrepreneur willing to take the entrepreneurial risk.
No, he need not be there as on the date you apply for that. Entrepreneur may take birth.
Or any time in the
future.
next 55 years.
That's,
My lords, entrepreneurs cannot encroach and claim that we are entitled.
but you have given lease.
Lease, whatever lease.
Should have taken
I'll
step
verify.
before
I'll
the court.
verify.
No, sir, he is a robber of the land. We can't entertain his claim. Otherwise, others start doing the same thing.
Same.
That is not your stand. And very strangely, the division bench says, allot the land to him. And he is saying, since already the court has said, I am under the shadow of the court order. Yes, you were saying that you had
Page 101, my lords.
101. Yeah, kindly read 39B and C.
Yes.
Famous judgment. I think Sanjeeva Coke versus Union of India. Justice O. Chinnappa Reddy's judgment. That followed Minerva Mills. Yes.
Certain principles of policy to be followed by the state.
Yes.
The state shall in particular direct its policy towards securing B. The ownership and control of material resources of the community are so distributed so as to best subserve the common good.
Yes.
And C. That the operation of the economic system does not result in the concentration of wealth
at
and
the
means
hands
of
of few.
production to the common detriment.
And that is so beautifully Justice O. Chinnappa Reddy of the Apex Court has so beautifully said about that. That our constitution is founded on distributive justice.
Yes.
If one cannot say all land should be granted to me to the detriment of others. These are the aspects.
Yes.
Just an agreement.
At page 101, my lords, is the letter of 1972.
This is by whom?
This is by the government of Orissa.
No.
And signed by the director of estates, who is a deputy secretary to the government.
Dated? This preceded the judgment.
Yes, this is in fact the inception of my case of expectation and stop. The undersigned
That contention you did not press into that judgment.
my lords,
You did not press that ground in that judgment.
it is the 1972, my lord. This letter is recorded by the lordships.
No, that's all. Yes, but the contention, legitimate expectation, estoppel, etc. You did not press those grounds.
Because what had happened, my lord, my cause of action was the determination of the lease on illusory grounds. And that is why I come to court. When I come to court, I disclose everything. And as a corollary to resuscitating my lease, their lordships also implement 1965 without in any way prohibiting me from pressing for the rest of the half acre. The undersigned is directed to invite reference to this application cited above and say that after careful consideration, government had been pleased to decide that the settlement of the backside encroached portions of the land may be made with him on payment of penalty of 10 times the premium and subject to his vacating the encroachment in the front as per the sketch map enclosed. I have
Subject to his vacating.
That, my lord, I have done so. It is on oath. It is recognized with this honorable court. What had happened, my lord, at a particular point in time, a petrol bunk was running. In order to regulate the ingress and egress, there was a island that was created. That has been removed, my lords. That this compliance with the condition has been made. I will,
Where is your application dated 27/12/71?
please. Page 33, your lordships will have it.
Go to 33.
Lordships have it.
What is the extent of land you have mentioned, please?
Kindly see at page 34, my lord. In view of the above facts. The lordships have it.
Where you said you have encroached this land
Yes,
in the representation.
yes.
Available is stated.
third paragraph, one line you have said, but without specifying the extent of encroachment.
Please,
You have only said
that
I have no alternative than to erect concrete walls and construct soak pits
in order to,
outside my plot.
yes,
Yes, that too. Possible.
Page 1 information.
if your lordships are also pleased to look at 102.
02. Even there you do not appear to have disclosed the extent of encroachment.
It is that.
They stated that some land is lying vacant.
It was weak.
You have not specified the extent of encroachment.
Your lordships may take it towards the subject matter of this the writ petition which is before this honorable court is the same as those in the OPP proceedings, my lord. I have today filed a translated copy.
Where they have said you have encroached.
Yes.
But you never said I encroached so much.
It is unfortunately from the record, it looks like it is communicated a little unscientifically. In 2006, I filed a IA. Same document, my lord, a translated copy is at page 3 of the memo that I filed.
What is that OS number 129 of 1988?
Yes, I am granted some protection. I approached the civil court.
What is the extent what you have mentioned there?
OS may not be
Part of
on record, but it is dealt with by the judgment of this honorable court, my lord.
What happened to OS?
It was dismissed for default. And after that, because there was determination, I came before this honorable court. This honorable court takes the fact that the OS is dismissed for default and nonetheless grants me relief.
Where is the description in the plaint? Come to 130, 135, 40. Have you described the
Schedule, my lords, is
where you describe that it is applicable of this? They have not given the schedules. Schedule is given. Even there, your client has not given extent of land. It appears very cleverly he has constructed the papers in order to get some land which he is not entitled to. Nowhere he discloses what is the extent of land he is encroached. Neither in the suit, nor in OJC, nor in this writ petition also, nor in his application seeking allotment of that land also. Nowhere he has stated. Although does not appear to be a straight man. Somehow he wants to grab the land.
no, if he wanted to grab the land, he would have stayed silent since 1969.
He grabbed land. Then he went for regularization of lands. That impression we can gather by just looking to all these things. Anyway, well, if they may make your case stronger also. Let us see in the afternoon. Yeah.
I am obliged.
Thank you for enlightening the court on so many aspects.
Pleasure.
Item 3.
This is the kind of preparation which I expected from standard lawyers. Yes.
Item 3.
This the writ matter was listed on 17th of July,
Yeah.
but on that day, due to viral fever, I just prayed for adjournment and I was allowed. And next time, when on 25th July it was listed, on the way, while coming to the court, I met with a road accident.
What you want now?
It was a restoration, man.
Restoration. We'll
Yes.
restore the matter. I dismiss this matter. I don't dismiss. Generally, this is the first matter I dismissed today. Because he did not come, I had put him to warning. Still, he did not come. Therefore, I dismissed. Again, I have given liberty to restoration also. The petition was dismissed by a learned coordinate judge of this court, void order date 2025 on the ground of non-prosecution. First, an application supported by affidavit is now more seeking restoration. First, a reasonable cause is shown. Any delay is there?
No, man. No delay.
A plausible reason, cause is shown seeking for restoration. First, ordinarily, dismissal for non-prosecution is not a happy thing to happen in any court, since litigants do not come to the court with joy and heart. First, no prejudice should be caused to the other side if the matter is restored to the board and heard on merits. First, in the above circumstances of the CMAPL of the petition having been favored, the order dated so and so is recalled and the petition is restored to the board for consideration. You appear for
Board of Secondary.
Board of Secondary Court. And with this non-prosecution, we should not dismiss matters for non-prosecution. Nothing will happen if we adjourn the matter. Yes. What is the matter? Tell now on admission.
To change the name.
Change the name.
To change the name.
Covered by
From Saddam Hussein.
Saddam Hussein is no more now.
No, Saddam Hussein, he doesn't want that he should remain with that name.
You have given representation.
Yes, repetition and this High Court order, according to this High Court's order also, my name has already been changed in the primary level. Only in the high school certificate, my name has not been changed and it has been rejected according to their rule.
You take that. Let it the panel consistently says requested or subnotice for petitioner to serve a copy of the petition along with all the documents before sunset of the day. If that is done, post this matter in the third week of December. Next.
Item 4.
May I please look up? My lords, the petitioner seeks a direction for refund of the earnest money deposit, my lords. The petitioner was the successful bidder, my lords.
You are for the petitioner?
My lord.
When have you changed your...
My lords. My lords...
Take notes.
My lord.
Take notice. Yes, emergent notice. Who appears for notice?
I'll take notice. This is MCL.
Is it a government body?
My lord. Public sector.
Next.
Item 5.
Item 5, I bow down for your lordship. My lord, here the petitioner who was serving as a reader, my lord, was allowed voluntary retirement with effect from 29 to 2020, my lord. My lord, limited grievance is praying for sanction of earned leave from a period of 1/2/2019 to 12/8/2000. My lord, I have filed a representation, my lord. That is at
Emergent notice. Who appears for OPs?
there are panel of councils, my lord.
Penal council are there? Or government?
My lord, here what my grievance is that I have already ventilated my earned
I
leave.
am asking you, who appears for the
I am for opinion 1 and 2, my lord.
OP2, my lord.
OP 1 and 2?
My lord.
Who should take the decision?
My lord,
OP2 shall take the director shall take the decision.
he recommended, my
To
lord.
take the decision
My
in
lord.
terms of your representation.
My lord, my lord.
Petition prayer.
Opinion number 3 recommended, 2 opposite dependent 2, my lord. That is pending with him.
Annexure 5.
OP petition prayer. Petition is recited by the representation dated
Dated, my lord, 4/11/2024, my lord.
24. A copy whereof avails at Annexure
5.
5. The same is reproduced as under. Next. Counsel for the petitioner submits that if a direction is issued for consideration of the representation in the light of recommendation made by OP number 3, justice would be met. Learned ASC Mr. Ray agrees to instruct OP number 2 to grant redressal to the petitioner in accordance with law in a time bound way. First one, this is appreciable. Next paragraph, 8 weeks. Open to solicit, sign for sign. Next.
Item 6.
Full S1.
Item 6.
What is this matter? What representation it is?
They're praying for verification of their reports, my lord. Annexure 5 and 6, the representation before.
Item number 6.
Representation to be considered.
Representation that annexure 6 is keeping in
5 and 6.
5 is the director, but government is to take decision. OP1.
OP1 has to take the decision.
Yes, ma'am.
Petitioner's representation dated 24/1/2025 at Annexure 6. AFC's grievance. First off, the same reads as under. Next paragraph. Counsel for the petitioner submits that if a direction is given to OP number 1 to consider the same in a time-bound way,
Keeping in view inquiry report at annexure 4.
Claim will be had. First one. He also tells the court that inquiry report dated. You are not telling the date at all. You are just standing like a mute spectator.
When the above date is there.
I do not know. You have to tell your lawyer you are paid for them. Dated 20 April
2021.
April 2021 needs to be kept in view while taking call on the subject representation, and the report is as an exempt form. Next paragraph. Learned ASC appearing for the OPs in all fairness agrees that the representation in question has to make its paid in due course. First one, we request the court to prescribe some reasonable time for taking a call on the subject representation, and also caveats that all contentions of the parties be kept open. First off, counsel for the petitioner accordance with the same. Next paragraph, 8 weeks. Same format. Yes, next.
Item 7.
In this matter, I was allowed RSCP, but subsequently revised under annexure 6, which I challenge.
Similar matters are
Similar matters, notice have been issued,
emergent notice.
and the interim order
Is requested to accept notice for all notice for OPs. First off, interim order, stay
and annexure 4 recovery order has been passed.
stay of recovery pursuant to impugned order dated 25/2025 at an exam for till next date of hearing. Yes, next.
Item 8.
Petitioner's husband, while working as assistant teacher, died during coronavirus, and petitioner got employment under rehabilitation assistance scheme in class 4 posts.
Change of date of birth.
Change of, your lordship kindly see in the school living certificate and college living certificate, my date of birth in 1979. But in the high school certificate, my date of birth was wrongly mentioned as 12/1/78.
How many years of sir? What you are doing now?
I am after my death of my husband, I am working on a rehabilitation as peon. Recently, appointment was made.
When the appointment is done?
Appointment is annexure 6.
I am asking the date.
23, 28/6/23.
28/6/23.
My lords.
How many, within what period you should apply for rectification of the date of birth under the rules? Other day Lanka was arguing. What is the period within which one should apply for rectification of the date of birth in the service records? Other day you argued 7 matters.
3 years.
3 years. Take accept notice. Yes, accept notice for the.
May I pray, my lord, I make fresh representation to OP1 let them considering Annexure 1 transport certificate, Annexure 3 school living certificate and college living certificate.
Where is the representation? You have not made any representation.
Yes, representation, my lords.
Have you made one?
No, I will make fresh, my lord. If your lordship
The
permit.
short grievance of the petitioner is against the wrong date of entry being made in the service records. First up, counsel for the petitioner submits that a direction may kindly be issued keeping in view the correct dates entered in the school records so that the service records are updated truthfully. First up. When asked, next paragraph, when asked as to any representation is made, counsel agrees that his client would make one and a direction be issued to consider the same in accordance with law. First off, this is fair. Next paragraph. In the above circumstances, petition is disposed of, preserving liberty to the petitioner to make appropriate representation to the jurisdictional authorities for change of dates of birth.
OP1, my lord.
Whichever. All contentions kept open. Next.
Time bound, lordship.
What time would you have not applied only? If such an application is made, the same shall meet its fate within a period of 8 weeks.
OP number 1, my lord.
Made to OP number 1. Okay.
While the petitioner was working as leader under the university, applied for post of professor under their scheme within time. But due to their official system, it could not be in time. So he approached this Hon'Ble Court. This Hon'Ble Court passed an order to consider. Now the impugned order has been passed under Annexure 16, page 54.
They have rejected your contention.
My lord.
Take notice.
My lord.
Emergent notice. AAC for one. Emergent notice to the rest. Next. Item 10.
Your Lords, I'm challenging the MCFC tribunal not taking up my reference. Annexure 5, Milords, has passed similar orders. But the only problem is here no reference, not even one single date has been taken over. Here it was taken once. In this case, it has not been taken up once even. 6 months have traversed in the meanwhile.
The short grievance of the petitioner is reflected in the prayer column. First off, learned counsel for the petitioner. This is on record a decision of this court in WPC 26599 of 2025 between Messrs. Asha Infra Projects Services Private Limited, Bhubaneswar versus Micro, Small and Medium Enterprises Facilitation Council, Cuttack, etc. This is disposed of on 23/9/2025. First up, counsel specifically draws attention of the court to para 3 of the order, which reads as under. First up, he submits that similar order be passed, facts being substantially similar in this case. First up, that is true. First up, in the above circumstances, petition is disposed of in terms of the order in the cognate case. Mutatis. Yes, next.
Another file has been attached there.
Send a copy of this order to OP. Only one OP.
Only OP1.
OP by speed post immediately.
The conjoint matter is same.
Same murder.
Yes,
Yeah,
and
yeah.
2 other matters are also pending, Milords. I'm giving a number. Same.
Give those.
Yes, much of this.
They send, call those numbers, create the list now. At least not 4 matters will go on. So post them immediately. Yes.
Item 11.
May I please, madam?
Yeah.
The matter relating to appointment under rehabilitation appointment scheme, my lord.
You go and get the file you have posted. I will send that one now.
Yes, madam.
The other one, so that we can dispose of unnecessary pendency.
Can you put it to Friday minutes? Would it be difficult to get
Tomorrow. Okay.
Friday minutes?
Friday?
Friday.
You are not in
minutes.
station.
I'm going to Delhi for some matters.
Okay.
Much of this. Much of.
Next.
Item 11.
Can I come back within a few minutes? A couple of seconds.
List came in 2015.
First preference is mother.
Mother, my lord.
Second is
Second is the
daughter.
second legal heir.
Baby.
Second legal is the daughter, my lord.
She was then child.
She was a
And
child.
attaining the majority, she applied.
She applied on 2015.
But the mother's application, what happened? Widow's
Nothing,
application.
nothing,
what-
my lord, not done anything.
Then that widow's application has to be
But
considered.
now, my lord, since the mother condition is not well, that is why after attaining the age of majority, the petitioner applied for rehabilitation appointment. And that is pending, my lord.
Where have you stated mother's condition? What is the age of the widow?
At the time of death, my lord, she was 25 years of age.
And she applied on?
She applied on
6.
mother, my lord. Mother applied on, my lord, 14/7/2003.
14/7/2003.
My lord. At that point of time, the petitioner, who is the daughter, was a minor, my lord.
She became major when?
She
Now,
became
what happened to that application?
Well, that application in 2015, a list came, my lord, by the Director of Secondary Education, placing the mother's name at serial number 10 for giving appointment. But that has not been carried out.
I will direct them to give appointment to her, not to you. You will be in appointment throughout for another 20-30 years.
My lord.
Let it go to the mother.
That since, my lord, the mother health condition is not.
Where have you stated in your
I have taken the aberment merit.
What has happened?
She is not well, my lord.
Well means catching cold or what?
Suffering from acute paralysis, my lord.
Paralysis.
My lord.
Where is the certificate?
That certificate is not there, my lord.
Petitioner is directed to produce the certificate of paralysis disease, which according to him, the mother is suffering from.
My lord, that certificate cannot be produced, my lord, because, my lord, she is there poor.
Doctor now. I will direct the doctor. Otherwise, you will dismiss the petition. Otherwise, it amounts to playing fraud on the government and on the court.
But since, my lord, since long the petitioner is pending, my lord,
That makes
no
no sense.
appointment has been given. That is why the daughter applied, my lord.
You say mother is suffering from paralysis.
Paralysis, my lord.
Direct the district surgeon to go and examine your mother and give a report on
Since,
that.
my lord, she cannot do government job, man. That is why, my lord.
I want to know whether paralysis has happened or not. You have taken up that contention.
My lord, I have taken.
Counsel for the petitioner draws attention of the court to the pleading that his client's mother, who is the widow of the deceased employee, is suffering from paralysis and therefore paralyzed from undertaking any government. First of all, the district surgeon of which place? Which place?
Dhenkanal, my lord.
Dixit is directed to visit the residence of the patient and submit a report as to her health condition, including employability, within before the next date of hearing. First of all, call this matter on 16/12/2025. First of all, registry to send a copy of this order by speed post to the district surgeon.
CDMO, Chief District Medical. CDMO.
CDM. Surgeon, CDMO.
District Medical Office.
If it is not true, I will impose 1 lakh rupees cost, or I may imprison the petitioner for 3 days. Yes. Next.
The petitioner is the wife of the deceased employee, my lord.
Widow of the deceased employee,
My lord, she claims
unless they have got plural husbands. Yes. After death of the single husband, she becomes the widow. There is meaning. Widow has certain rights, wife has certain rights, daughter has certain rights, woman has certain rights. Therefore, English language, as a lawyer, you should be very careful in using that. Yes.
so much she claims of some benefits, the service benefits of her late husband. And according to my lord, while her husband was alive, he had filed a WPC before this honorable court on the annex of 5. This honorable
Consider.
court, for consideration, but as on today, there is no consideration. And in the meantime, he has already been died, the husband of the petitioner. So, my lord, she's to get the benefits and since her husband has been died, some pensionary benefits she's to get, my lord.
Pensionary benefits are also not given to her.
Not.
The periodical increments are not given.
Increment and the pay revision, it was not granted while he was alive. And
But pension is given.
no. That is
And also, where is the prayer?
prayer is there.
Where is that?
In last 3 lines.
Pensionary benefits. Pension and pensionary benefits.
Let her file a representation. Shall
So what happened to representation given earlier?
No representation.
No, it's given. There is an order. Not only representation, there is order by the court in favor of the deceased.
Yes. This
Again, representation. Take notice.
Yes.
I'll call this matter in the only representation jurisprudence you have developed. Orissa High Court has developed beautiful representation jurisprudence. AGA is requested to accept with Lanka accepts notice for OPs. Matter lies in a narrow compass, and this is a second round litigation relating to pensionary benefits. Personal. Therefore, call this matter in the third week of December 2025. Okay.
Item 13.
In the meanwhile, if the representation is considered, you can report. The pendency of the petition will not come in the way of disposing of petitioner's representation.
Husband of the petitioner.
Right?
Husband of the petitioners.
Representation is of the husband.
Yes, sir.
Petitioner's husband's representation, who is since dead and gone. Okay.
Item 13.
I'm challenging the order of rejection where my regularization has been rejected by a similar notice has been issued. I have supplied the copy.
Issue emergent notice. Go to cost titles. All Lenka for all of this.
Yes, sir.
Mr. Lenka, the DG accepts notice for all of this. Call this matter along with WP number. So next.
Item 14.
My lord, I am challenging the order of the annexure 15 rejecting my application for grant of UGC scale of pay as per direction of this code dated 31st August 2024.
That was only for consideration.
121.
That was for consideration.
Consideration.
They have rejected on what ground?
They have rejected
Required minimum
my
55% marks in PG. I have to enter direct payment fold. Granting it as on 1489 plus 3 degree. You have not complied with, and therefore they have rejected. What is wrong with this order?
My lord, similar cases have been disposed of and they have paid the UGC scale.
Which is that?
As at page series.
Show that.
The judgment is at running page 103.
Go to 103.
103. Judgment of this court, similar placed persons in the same college, my lord, I was working.
They have
And
been paid now.
she was secured less percentage of marks.
Okay.
I have secured 62.5% marks, down MPhil,
Issue
PhD,
emergent notice.
and
All right. Issue emergent notice. Link up for 192. Yes.
Item 15.
My lord, the petitioner challenged the letter dated 10/7/25 annexure 6, my lords. The opposite party not allowing the petitioner
To join
in the school, my lords. So the DO has not given any direction to the petitioner regarding the suspension or disengagement.
where is your appointment order? If you are not, you are
Annexure
prevented
6.
from working.
My lords, annexure 6,
Annexure 6.
page 40, my lords.
What it says?
Next 6 is the rejection order, and he has not challenged that order.
But in that order? Suspension order.
No, my lords, no suspension, my lords.
Fake certificate, mark fake certificate.
Ah.
That for that reason, that has been rejected. Your Lordship, last para, page 40.
My lord, so-called reply is rejected, my lord. 10-10-25.
That the matter was heard on the opposite party number 4 petitioner. During the course of hearing, the Premanand Sahu petitioner of the case has asked to submit any documentary proof on the verification report furnished by the Assistant Registrar Examination, Sambalpur University, Jyoti Vihar, Burla, in letter number so on the graduation mark secured by him.
647, but he made 747.
Yes.
My lord.
Says how has failed to submit it. Where is your document to show that you have secured so many marks? Results, no merit for consideration, but subsequently how has submitted a written statement mentioning self-result in document table. How to be in the Fine. So this is the inquiry report. Where is the order of termination?
My lord, no termination.
Huh?
No termination.
Where is the termination, Mr. Lenka?
No, there is no termination order.
But
only this rejection order he has filed but not challenged in the prayer. It's issued on 10-10-25.
No, unless you on that ground remove,
yes,
the vinculum juris of employer-employee will continue. The relationship of employer-employee continues.
Only the joining report was not accepted.
Correct.
Annex 7.
Right.
Annex 7.
Where is the termination, dismissal, removal, discharge?
That I'll take instruction.
Lenka accepts notice for office. Matter lies in a narrow compass. Call in the week after next. Okay.
Item 16.
I beg your pardon, my lord. I may be permitted to place the matter on BC, my lord.
Item 16.
Item 16. May I please your lordship? I am on BC, my lord.
The representation
On leave.
Annex 9.
No, you have rejected already. Accept notice.
Yes.
Yes. 1 and 2. Emergent notice to 3. Yes. Next.
Item 17.
May I please your lordship?
Yes.
The petitioner is working as Sikhya Sahayak. Her claim for antedation of a service has been rejected by Annexure 11, your lordship.
What we have done in similar matters? We have done with retrospective effect, it should be given, na?
Yes, your lordship.
Yes, Mr. Lenka is requested to accept notice for 1 and 2. 1, 2, 3.
Yes.
Yes. Next.
Item 18.
May I please your lordship? The petitioner who is a retired employee of an aided education institution.
Gratuity is admissible with effect from date of his pension along with gratuity. Pension also not given.
No, your lordship. I am receiving only the provisional pension for 2023.
Since 23?
My lord.
Why provisional?
Yes, your lordship. May kindly see Annexure 16, page 48.
What is that?
I have made a representation with the principal that I have retired from the year 2023. That I should receive the regular pension. Even I have, but they are stating that you have not produced the notice certificate.
Notice certificate.
How can I give that? Page 16, I see page 48, Annexure 16, I kindly see your lordship.
Take notice. Emergent notice.
What I pray before your lordship is that because after the principal stated, so I have made representative before the Director Higher Education under Annexure 17. That is pending. If they can take the action over that, your lordship.
Short grievance of the petitioner is as to non-sanctioning and releasing of the regular pension, although provisional pension has been accorded. First stop. Counsel for the petitioner submits that for the purpose of sanctioning the regular pension, the principal of the institution is insisting upon the production of no due certificate, which he is not in a position to produce. First stop.
Which I cannot produce. It is up to the principal to give.
That's one. Therefore, he submits that his client has already made a representation dated 18/8/2025 to the Director of Higher Education at Annexure 17 and another representation to
one representation.
Representation.
It's a receipt I have enclosed.
No, you have made a representation, na?
Yes, to the annex, to the OP number 2, your lordship.
OP number 2. Dated 18/8/25.
My lord. With that, will be received also.
25. Which reads as at First off. Next paragraph. Council submits that if a direction is issued to OP number 2 to take a call on the subject representation, justice may be meted out to his client. First off, with this submission, counsel for the AGA, Mr. Lenka, appearing for the OPC is agreeable. First off. Next, in the above circumstances, 6 weeks. Open to solicit, no course, we are boast. Yes.
I'm much grateful.
Item 19.
Met my lord.
Yes.
My lord, here the prayer is for UGC scale up pay, your lordship. This is the second round of litigation. This honorable court had directed to submit a representation and
From the date of acquiring what qualification?
the qualification for minimum qualification, that is MA and B leave, your lordship.
First exam. Yes, Mr. Lenka, you accept notice for 192. 192. Mr. DSG Pari is requested to accept notice for 3. Emergent notice to 4 and 5.
I am appearing
For 4?
3.
UGC? Yes. 3. So accepts notice for 4. Emergent notice to Utkal University who?
Mr. Patnaik.
Sri R.K. Patnaik.
T.N.
Patnaik. The panel counsel is requested to accept notice for 5. Copy 5. Petitioner to serve copies of the petition along with all the documents on the panel advocates immediately. Okay. Next.
Item 20.
Please, Your Lordship.
Yes.
Petitioner pursuant to Annexure 1 and 2, they applied for the post of junior teacher schematic in the year 2023. Here,
Kumar Tharia is cover say.
Your Lordship, here there are other similar matter in which Your Lordship are directed for issuance of notice.
All right. We'll issue here also.
Your Lordship, the whole point is on reservation. More than reservation,
Accept notice for OP number 1, 2, 1 and 2. Emergent notice to the rest. Okay.
let it be tagged with those similar matters.
Yes. Tag it. Yes. Next.
Item 21.
Item 21 may please, my lords. First, this writ petition has been filed seeking for my lords departmental inquiry against opposite party number.
Who are you?
My lords, I was illegally detained and my lords, I had been subjected to custodial torture, my lords. And due to which your lordship may come to annexure 2, my lords.
And there 2 is the order.
Order, my lords, in the said order, taking note of the same, my lords, relevant portion is at paragraph 9, running page number 23, my lords.
What was the offense alleged against you?
My lords, there were several offences, which also includes 109 of BNS, my lords, and 2527. But my lords, I was detained for more than 10 days, my lords, violating Article 22, Clause 2, for which I have been granted bail. And my lords, there was a clear direction with regard to my lords, production of CCTV footage and other things, my lords. Even if STJM has ordered the same to opposite party number 4, the same has not been carried forward, my lords. So, my lords, to that effect, may I just rely on the my lords. Paramveer Singh, my lords, where the CCTV is a mandate in all the corridors and
police stations.
Yes, my lords. That has not been carried out, and my lords, till date also, the IIC has not produced.
So, if representation is considered, you will be happy.
Yes, my lords. In light of
that decision.
That decision, and even if Supreme Court has taken so much cognizance recently on that matter.
That representation.
Annexure 3, my lords. I have given all the relevant.
When while disposing in earlier writ application, that revision, coordinate bench has taken all the
grounds, my lord.
All the grounds, my lord.
But in the light of that, this representation should be treated by you.
Yes.
By the Director General of Police.
Opposite party number.
Petitioner's representation dated 26/10/2025. A copy whereof avails at Annexure 3 series is addressed to the Director General of Police, Odisha, for taking certain action against the alleged illegal detention, custodial torture, and abuse of authority by police officials of the Special Squad, Behrampur.
IAC, this is not special squad. This is
He
IAC.
has said that way.
He has been connived with IIC Badabajar, my lords. He was present, my lords. But specific allegation with regard to IIC Badabajar, opposite part number 4.
First off, essentially the allegations are made against OP number 4. First off, counsel for the petitioner highlights the coordinate bench decision in criminal revision petition 706 of 2025, heard and disposed of on 13/10/2025 with certain observation. First off, he contends that he argues that if a direction is issued for considering the subject representation, his client would be happy. All right, next paragraph. Learned AGA Mr. Mohan, in his usual fairness, submits that he would instruct OP number 2 to look into the grievance of the petitioner as has been aired in the subject representation. If petitioner 2 cooperates, first off, this is appreciable. Next paragraph. Thanks.
My lords, in light of decay and
consideration should happen inter alia keeping in view on the apex court decision in
Hon'Ble Singh and my lords DK Basu versus State of West Bengal.
DK Basu is the latest judgment, na?
DK Basu is
the older judgment.
My lord,
Older
that is
judgment.
with regard to custodial torture, my lord, and this
Decision in Paramveer Singh Saini versus Baljit Singh 2021 AR 2021 SC 64.
and my lords DK Basu with regard to custodial.
Here it is everything is
No, my lords. This is with regard to CCTV footage because
DK Basu versus State of
West Bengal, my
West
lords.
Bengal. AR
1997 1 SAC 416.
1997 1 SEC
416.
I'm grateful, my lords.
Item 32.
This matter is with regard to the petitioners are terminated employees of ordinary recognized private high school, your lordship. As per the circular dated 27/3/1983, the appeal lies to Director Secondary Education. Accordingly, the petitioner preferred the appeal, which is under Annexure 9 series, your lordship.
It is pending.
It is pending before the director since more than 1.5 years.
Petitioners departmental appeal against termination from service is pending on the file of
Director Secondary Education.
Director Secondary Education for a long period, is his grievance in this petition. First off, learned counsel for the petitioner submits that right to speedy justice is not confined to judicial process but extends to other quasi-judicial bodies as well, and therefore intervention of this court is eminently called for. First off, learned next AGA Mr. Mohanty, in his usual fairness, submits that although there are many pending cases and other works to be accomplished by the concerned official, he would instruct OP number 2 to look into the appeal papers and dispose of the same within a reasonable time if all contagions are kept open. First off, this is appreciated. Next one, 3 months.
Grateful, Lord.
Next.
Item 23.
Yes, my lord. The petitioner is working as a lady attendant of OP number 3 college, opposite 3 college. While she was continuing as such, the principal of the college asked her to give the appointment order so as to go for the verification before the director of higher education, my lord. And with a bona fide belief, the petitioner handed over it to the principal. But the principal, what he has done, you lords may kindly see, he has Completed the appointment order under Annex 3, page 54. Page 54. Everything has been written in the typographical method.
Take notice. Let them take notice.
I have filed a grievance before the director. For the mischievous activities of
pending.
For the mischievous activities of the present principal, my lord, there was an inquiry by the government, and the government has directed. Your lordship may kindly see Annexure 6, page 62. The director has directed the sub-collector of the sub-collector being the president of the governing body to look into the matter and to submit the fresh proposal in respect of a senior staff instead of the present principal. That's because there are some allegations against him and he has practiced fraud. Page 62 for a moment.
Yes, you said that.
Yes.
I believe. Yes.
So what there are
So representation is considered, you will be happy. Or notice should be issued. Let notice go. Emergent notice. AGA for 1 and 2. Emergent notice to the arrest. Yes.
Item 24.
May I please note?
Yes.
Here the petitioner was initially appointed trained as a teachers. And after rendering around 30 years of service,
That scale of pay is not legal.
regular promotion was given, but no financial benefits.
Any representation you have made?
Annexure 9.
So you received the issue notice.
Issue notice.
You have to decide the matters.
AG is requested to accept notice for all. Okay.
Item 25.
Why even after giving promotions, the pay is not
Regular promotion.
Yes.
Item 25.
Members. Petitioner was given a RSCP under Annex 13 ballot, and he was, after giving RSCP, he was allowed to retire. Well, that is Annex.
Re-examination. Re-examination.
That is impugned order. That is
Page 99 and 22.
Take notice.
And they have been suggested for compliance of resubmission.
balance. That is in view of that is letter of the government, that is 7/7/2007. That letter speaks 7/7/2007 under Annexure 12 running page 7.
Emergent notice. Stay of impugned order till next date of hearing. You have filed application.
Well,
Well, yes. Till next date of hearing. Yes.
Item 26.
Passover. But you are a proxy advocate.
No, I have the power of the files with all the clergy senior.
Take file. Take our file. Give file. I will assist you.
I have some instruction. I'll just sit out and come.
This is an application before the Raulkala Development Authority, wherein in absence of the chairperson, the ADM is in charge. So for allotment of that land and mutating the same, they have called for the personal attendance of the parties concerned. So in one day, though they have appeared and two of them are absent, so subsequently they have fixed the date on 24/7/2025.
Why party should come there? Any Vyavhar?
No, but that is a
For allotment.
personal hearing so far the allotment by the Raulkala Development
No,
Authority.
what is that personal hearing?
That notice was issued at Annexure 6.
Correct. What is that personal hearing in matters like this? All applications.
No, because legal heirs are there, they have to put their objection. So for that purpose, they have called for the legal heirs of the deceased. And they have fixed the date on 24/7/2025. The updated information they have. So that under challenge that on the day when it was deferred, though other legal heirs are present, so why for the other date? That is the subject in brief.
Not Passover. Or you take notice.
And one password, madam. Just
Okay.
Item 27.
May I please, Lords?
Yes.
This is similar to today's item note 20, Lords, that is Rajesh Kumar Dhore was the state of Rajasthan.
That reservation vertical and horizontal, that Rajesh Daria, in similar matter, notice has been issued.
Issue emergent notice. PGA for the OP numbers 1, 2.
The private parties are there, my lord.
1 and 2.
Who are for 1 and 2.
How many states of Orissa are there in the Indian map?
One.
Then why you have written 2? You want to divide the state or what?
State project director, my lord.
Huh? State project, you are right. Yeah. State issue emergent notice. Mohanty accepts notice for 1 and 2. Emergent notice to the rest. Yes.
In this matter, my lord, I have also filed one similar matter, my lord. They have also mentioned my writ number. In that case, my lord.
All this WP number. Your matter has not come up before the court.
No, my lord.
Then it has to
only
come. When it comes, you mention.
Okay.
Okay.
My lord, I have to file an amendment petition to that. So for that reason, my lord, I
give one small cheat to
my lord,
this matter day after tomorrow. Because we have issued notice in this. That was it. Yes.
Item 28 has been adjourned. Item 29.
Nine, my lord. Similar RACP matter. Your lordship,
Covered by judgment.
Covered by your lordship's order.
Yes.
And in.
You have changed the.
Yes. And also my prayer may be quoted as per the in present reports.
Yes. His prayer should be pleased.
Fine. Congrats.
Yes.
Item 30.
Made prisonership.
Yes.
The petitioner is an assistant teacher in the government high school.
Please grab that mic. Yes.
Petitioner is a assistant teacher in the government high school and subsequently so cause is being issued against her. That is, fake BD certificate is issued, submitted during the employment. That's very similar case. WPC number 31662, dated 11th November 2025. Receipt has admitted the case and issued notice to the opposite parties.
Well, we should notice also. In the same inquiry.
Same DU, same district.
Same DU.
Person
is different.
Like to take notice, issue emergent notice. One take some notice for 1 3. Yes.
Item 31.
May I please your lordship?
Different case.
You may kindly see, my lord, annexed to page 14, my lord. That is a defective legal error given to me, my lord. So we have given in that regards
rectification.
Rectification, my lord. In this way, it is also be honorable court to decide. And a Tahsildar direction hele, your lordship, that is erroneously corrected, my lord. Only one son, myself, my lord. But here is given that is 4.
Yeah, you have to make representation.
Yes, my lord.
For this one.
Yes, ma'am.
We'll follow this. Let him make representation. Let it be considered because the other judge has said like that. The subject matter of this petition is substantially similar to the one in WP 28415 of 2025 between Ramakrishna Panigrahi versus Tahsildar and another. Heard and decided by a coordinate bench of this court. No, Radha Krishna Panigrahi versus Tahsildar and others, heard and decided by a coordinate bench of this court by order dated 6/11/2025. First, the said order, the relevant parts of the order, namely paragraph 3, 3 4 and 5. Read as under. First. Next paragraph. Learned counsel for the petitioner is right in telling the court that similar cases should be treated similarly and therefore relief accorded to the litigant in the coordinate case has to be extended to his client as well. First, next paragraph. Ordered accordingly, and writ petition is disposed of in terms of judgment in coordinate. Yes. Give this. No, we need that. Yes. 32.
May I please, your lords? It's not contempt, lords. Annexure 1 is the order of lordship. Order dated 8/9/2025, page 9, lordship, may kindly see. And here, my lord, the petitioner, my lords, what
was the order?
4.3, page 11. Petitioner joined in 90, retired in 2018. Not a single fine as remuneration has been paid to him. 4.3, your lordship has been kind enough to make this observation and direction.
Issue police notice to the OPs. OPs are to be present before the court personally on 16/12.
Grateful.
First. However, presence shall not be required if in the meanwhile compliance of the order is reported.
Grateful.
Okay.
Deeply grateful.
Item 33.
May I please, my lord? My lord, this is case related to the rehabilitation assistance scheme, my lord. In between, that scheme has amended, my lord. In the amendment notification, I am eligible for the amendment, my lord. Amendment notification, my lord. Praying for dispose this restart application with that direction, my lord.
Any covered
Yes,
with
sir.
the judgment?
Yes, ma'am. This is the amendment
Is
notification.
it you covered by the judgment?
Yes.
The judgment. We have read some judgment.
I have not the judgment, my lord. Not judgment, I have not.
Yes, I have the
Lordship order.
Lordship order. Yes, bring that judgment. We'll give that judgment.
Yes,
Second prayer of the petitioner reads as under. First off, learned counsel for the petitioner submits that in a catena of decisions, this court has already made orders keeping in view the notification dated 4/4/2025, whereby the Rehabilitation Assistant Rules 2020 have been suitably amended, and that would inure to the benefit of petitioner. First one, this contention is not disputed by the learned ASC. First one, in view of the above, petition is disposed of, directing the OP number.
Not all, my lord.
All how all will they sit over the table and discern? Some OP has
4, my lord.
OP number 4 has to consider claim of the petitioner for a compassionate appointment in the light of the amendment rules 2025.
That judgment is Jitta Luha.
Keeping in view the decision of coordinate bench of this Apex court decision in so and so. Please give that. Write down and give it. First off, time for compliance is 8 weeks. Okay.
Item 34 has been added. Item 35.
Lord, IA number 1223325. This petition I have filed, my lord. I am not getting the salary since April 2024.
April 24.
24.
Who appealed for the OPs?
OPs, my lord, central government responsible, central government council, and IMD is appearing, and state government, OUAT. They have said they have sent the budget composition and the amount I am entitled to get, that they have said. They are saying that it is not scheme has been closed and scheme closed, so no payment can be made. And agriculture department, IMD, both are responsible for this. And the document of what I have said.
What do you say?
My lord, actually the panel counsel is engaged in another court. I'm for OP number 4. His IA is seated at OP number 2 and 3, which is the central government.
Where is the council for OP number 3, 2 and 3?
2 and 3, my lord.
2 and 3 responsible for releasing the funds. You'll also kindly see the complete death chart of the mistakes and the order. The document I have filed.
Correct. But in the absence of the lawyer, you want to argue?
No, let him say.
Let him come.
Then your lords may please fix it at 2 o'clock.
Today we have another heavy matter. No?
Since
we'll have it next week.
Difficulty, my lord, I'm not getting salary. If your lords fix the date,
I'll fix it. Call on 27.
No, 1 year, my lord, I am in difference.
Anyway, that will be paid on the first day of the calendar month.
They have taken twice time for filing counter reply.
Call on 20.
Now nobody is there. Monday?
24. Yes.
Item 36.
26, my lords. This month. 24th of this month.
36, my lords. I am for the opposing party. I have filed the applications for vacation of stay.
What is the matter about?
My lord, it's a matter where 2 persons, in fact, 2 cases are there before your lordship. Both the persons were appointed on ad hoc contractual basis way back in 2007-9. Thereafter, they continued as such, and subsequently in 2013 they were regularized. Regularized in the sense the attempt was made to regularize them, because the parent department, the Science and Technology Department, the consent is required from, approval is required from them under the bylaws of that institute. That Science and Technology has to, since it's not a sanctioned post, it has to be obtained, the approval has to be obtained from the Science and Technology Department. They have the governing council of the institute. They decided no, excess amount has been paid in salary. They have not been recruited in proper way by way of an advertisement. Thereafter, they have to refund that excess amount. Against that, the petitioner came up in 2020, that this happened in 2013. Yeah, they filed writ application in 2014, wherein this Honorable Court directed no recovery from their salary. Subsequently, that case continued and was disposed of in 2023, wherein this Honorable Court directed that you decide on the basis of Rafiq Masih whether they can recover amount.
What is their group status?
My lords, pardon?
Which group of employees?
One is the performance
program executive. Both are class 3.
Class 3.
So, my lord, it cannot be as per Rafiq Masih and Thomas Daniel's case, my lord.
Rafiq Masih is not applicable. Class 3 is applicable.
Yes, my lord. Class 3, class 4, both.
Class 3, class 4, both.
My lord. Rafiq Masih and Thomas. Group C, Group D.
Group C, Group D. Group C, Group D.
Group C, Group D.
And what remains in
No, my case before your lordship is that will not apply because of the fact that since they obtained when the immediate, there are certain case laws where your lordship will kindly appreciate, where the decision is taken immediately within a very short period of time, and it involves the taxpayers' money and certain other contingencies, which I'll point out to your lordship. I have the citations with me, that in these cases, it can be recovered. So where there's particularly when the initial appointment is not in accordance with law, and the decision has immediately been taken in a very short period of time, and that involves the taxpayers' money.
But they worked in that post.
Yes, they worked in that post.
Even then you will recover.
My lords, the committee.
That was then, my lord. And
the question is, did they work in a post which they allegedly wrongly held? Have they worked or not?
No. They are not the case. They have worked in a post which was created for that purpose, temporary purpose. They continued temporarily for a certain period of time, whereafter the committee, without obtaining the appropriate approval, had decided that they should be absorbed to this post. Thereafter, the governing council, which came up subsequently, they decided that no, since the parent department, Science and Technology, has not approved this, and they have pointed out various irregularities in other appointments also. So similarly situated, all those people, they were said that they cannot be absorbed since salary cannot be paid to them in a pay scale. Thereafter, this one was taken.
My question is,
my lords,
have they worked in the post to which they were appointed?
Yes, they were.
If they are worked, how can you recover the money?
That will be my case before your lordship.
That is the case to be decided.
Yes. Yeah, I'll put forth my facts along with my citations. That your lordship will decide on that.
But that's the argument over.
My lord,
What again argument?
if I may permitted to place the citations with regard to.
For that, no installment. You should be ready with your citations.
Yes, I'm ready with my citations.
I'll give that. Yeah. If once he works,
I understand.
can't recover it all.
I'll try to distinguish. That is up to your lordship to decide. I'll try to.
Well, others may come up. We need not wait. This case I'll complete and I'll also go for lunch. Don't mention anything when matter is going on.
Lords, I've just not indicated. I'll assist your lordship because.
No, if my straight question arises because of the state of Gujarat versus Hon'Ble High Court of Gujarat, 96 or 97. So can take out that judgment. Once they work in the post, then no recovery. Unless you have given wrong pay scale, etc.
Yes, that
is it your case that wrong pay scale has been
wrong? No, there's a coupled fact. In fact, appointment was irregular in a sense. There was no advertisement, and they were made to work.
It is irregular appointment.
Subsequently, a decision was taken with the seeking an approval from the Science and Technology Department that pay scale be granted, but Science and Technology Department said no, since the initial appointment is not in terms of the advertisement and they have not been properly sanctioned, this cannot be done. Hence, decision was taken that in the meantime, the previous governing council, which had taken a decision to pay the pay scale to them, that was directly recovered from them.
How? Then what should remain in their hands? Nothing will remain.
But the differential amount, when they were given the consolidated pay.
Consolidated pay was granted to them.
Yes, consolidated pay was granted to them. So the differential amount was decided to be recovered, not the entire, the differential amount. So that is my case where the differential amount is with regard to such an appointment where the initial appointment was not in terms of the advertisement. And was not and in that they also admit that they are initially contractually engaged. I have tried to distinguish by these judgments which I have given for the purpose of IA. Because the main case, I have other judgments, including a decision of the.
You argue the main case also. Well, I'll fix a date.
Yes,
we'll fix the date and we'll dispose of the main matter itself. What this judgment says, Dilip Kumar Mishra.
My lord, this is the cost title.
This is the present petitioner.
These are your notes.
Yes, these are notes. I've just extracted the relevant judgments. For your lordship's immediate reference.
Okay.
A, B, your lordship sees B, and then C, D, I given, and the reasons that in view of these facts. And this is basically on the IA application. That's why I've written for vacating the interim order. I've given the heading for that. With regard to the main case, I'll place other citations before your lordships.
Along with main case only, you kindly give citation so that once for all we can.
Yes.
My lord, I have also received the counter. Yeah. I'll also file a rejoinder in the meantime.
And one small, if your lordship may direct this Science and Technology Department, in case they want to file any counter, the pleadings may be completed.
Yeah. On this matter, in the second week of January 2026, first off, in the meanwhile, the concerned OPs may file a counter if any. Okay.
My lord, interim order to continue.
Interim order to continue till next date of hearing.
We have filed item 30. We have filed the compromise. The 1972, what was we agreed when we called on 30th, the 3rd December.
3rd of December.
3rd December.
But I'm likely to be all right. It will go before some other bench. Call this matter on 3rd of December. As requested by both the sides. Okay.
42.
Okay.
I'm sorry. I'm so sorry.
No, sir.
In that matter, in fact, after the communication of the impugned orders, a slight error had occurred, inadvertent error, for which the authority actually amended the orders, which was communicated to the petitioner. And as a matter of record, it's there on the record, also on the counter affidavit. Now, in case they want to amend the rate application, they may, by virtue of that.
My lord, verbatimly, they have again reproduced the implement orders.
I know typographical error.
Concept for the contesting notice brings to the notice of court that the rectified order has been passed subsequently, and that is made a part of record in his pleading, and therefore, if the petitioner wants to file any subsequent pleadings, he may do. First, submission is fair and therefore noted. Yes, Mr. Mishra, why are you waiting?
Next item is when the Lordship had directed them to file counter in this case.
They are not
It is a covered matter. This is a covered matter. 37.
We have received the draft counter only 2 days time to file.
Week after next, we'll have that. Not yes, week after. That's the question.
Date may be postponed.
Now 82 years old, my lord.
Yes.
82 years old. On last occasion, on 27th Jan, the lordship directed government to take within 1 week to comply the earlier order of the court. That is payment of some area salary, about 60,000-70,000. The lordship directed on 27th to list it within.
What you want now?
Can you take up today or next week under press admission heading press admission so that you can reach. Next week on the press admission heading, so can you reach? Today also.
Kindly wait, let us.
Yes, I was.
I am in the in another matter. I'm in halfway through area.
Yes.
Okay.
Okay.
Yes. Yes.
Item number 2.
Yeah. Anything to add from your side?
Well, it's in reply. As now my submission.
My lords. My lords.
It's a question.
My lords.
Totally, how many acres the layout is?
0.5 acres. Half acre.
Entire layout.
My
Many
lords.
sites.
Once, my lords, initially he was allotted half an acre of land.
Correct.
Then, by virtue of order of this honorable court in OJC, 1965 square feet was allotted in favor of the petitioners. Now, my lord,
first allotment is dated.
It is dated 10/6/1960. My lord's allotment.
1967.
My lords, building 21/3/1967.
21/3.
My lords, 21/3 executed listed, my lords. 21/3/1967.
Extent is half acre.
Half acre.
Well, 21/3 is the date of the registration.
Yes,
Registration of
yes.
lease.
Lease.
19/3 is lease.
My lord.
Please.
Okay.
My lords, kindly see the prayer of the petitioner. My lord. At page 22.
Encroached land at the backside of the petitioner's plot should not be settled on to him on payment of premium. If the apartment of so it mandamus for settlement. Settlement not to take any coercive action against the petitioner.
My lords, no provision of law is spelled out under which provision of law the enclosed land should be allotted to him, my lords.
Will not power to allot land include power to allot encroached land also?
My lords, provided there is a provision of law.
Allot encroached land.
Encroached land. And somebody will encroach today, will say tomorrow I have right to be allotted. It is no, there is no provision to that effect. My lords, what I humbly submit, my lords.
But that was not the contention you took up in the earlier round of litigation.
My lords, I am coming to that, my lords. My lords, the judgment passed in 13/3/2003 in OGC number 5810 of 1996,
dated
13/3/2003. My lords, this judgment was affirmed by the Supreme Court. So,
SLP number?
SLP number.
You had challenged it.
My lord. So, my lord.
Anybody can give SLP number.
My lord.
SLP number 9028 of 2003.
9028 of 2003 is dismissed on 21/11/2003.
Dismissed on
21/11/2003. The reference is at page 49. Your lordships may see Chapter 7, page 49.
Yes, ma'am. My lords, now my first submission is that in that writ petition, this honorable court has adjudicated all the disputes till 2003. My lords. Now, my lords, kindly see the operative portion of the
para 9. Paragraph 9 of the judgment.
My lord. My lord, what is directed in this case? The determination of lease, which was challenged in the writ petition, was allowed, and 1965 square feet, which has been encroached, that was regularized on payment of premium of rupees 4 lakhs.
Yeah.
My lords. After that, my lords, kindly see the pleadings after that. What has happened? Page 18, para 25, my lord. May I place, my lord?
Yeah.
That in the meantime, the government, in obedience to the order passed by the Honorable High Court of Orissa and Honorable Supreme Court of India, have settled the encroached lands in front side of the petitioner's plot as per the agreement dated 30/10/2003. The back side of the encroachment remain uncertain. The petitioner giving details. My lords, he has submitted a representation dated 10/9/2004, claiming that I have also encroached some other lands that may be allotted in my favor. But that was never recognized or approved by the government. So there is no concluded contract or any promise by the government to settle. And it cannot be also, my lord. So it is going on encroaching some part of the land and asking for settlement.
Yeah.
Then, my lords, kindly turn to page 19, para 27.
Petitioner in OJC number 9. So,
my lords, here, my lords, in this para, he has claimed adverse possession, title bio of adverse possession. My humble submission before my lords is that adverse possession cannot be decided in a writ jurisdiction, my lord.
Though they have taken up, he did not plead that at all.
My lords, that is in the pleadings. That is what I brought to my. What is the basis of the claim, my lords? There is no basis. After judgment of this honorable court in OJC, there is no cause of action. So this writ petition is not maintainable at all.
Yes.
My lords, the writ petition is defective since the state has not been impeded through appropriate authority. My lord.
To whom the land belongs?
State.
To whom the land belongs?
The state of Orissa.
State of Orissa. But state is not a party.
Is a party, but has been represented through Director of States.
Right.
If your lordship will see section 79 of the CPC, it is only secretary can represent the.
Not kindly see respondent number 2.
Secretary is also there.
Yes, yes. First of all, the director of estate is an ex officio secretary.
But in my writ petition, it is not there. That is why I am saying.
The court writ petition, let us see. State of Orissa. Whose cost people?
At page 4, my lords.
Ex officio joint secretary to the government of Orissa.
And kindly see respondent number 2.
Cannot be. Where is this?
Represented by special secretary to government.
My lords, that is not reflected in my writ petition.
It appears in there.
Because we have taken that stand in our objection.
In the court proceedings, it is there.
Objection.
It is there for that.
Benefit of the screen, my lord. It is there.
So, my lord.
So that contention may not.
No, my lord.
You give up that.
My lord.
Yes.
My lords, there cannot. My lords, the prayer is to direct the state to settle the land because of the encroachment of the petitioner. The trespasser cannot claim title or any right over the land, my lords.
Okay.
And the argument made by the petitioner regarding acquiescence, waiver, and estoppel doesn't operate beyond law, my lords.
Yes. Yes.
So the petitioner absolutely have no case. The petition is liable to be dismissed with heavy cost, my lords, because the land is very valuable land now. My lord. By this process, they want to grab the land.
How many sites have been formed in the layout?
My lord, that is not there in the petition or.
No, I am asking you.
My lord,
because you have formed the layout. No? Industrial layout is formed by you.
My lord, now
any legislation?
No, my lord, now this Kharbal Nagar, the situation of the land, there is no industry there. It is purely commercial and residential area. It was converted and it is earmarked for industrial purposes.
Is there any industrial development, Industrial Areas Development Act in your state?
Yes, yes.
Which is
that is IDCO, my lords.
Which is that?
Orissa Industrial Infrastructure and Development
Do you have
Act.
that?
Corporation Act.
So this land is no more used for industrial purpose.
Yes.
And in our counter, we have specifically stated that the land is, the remaining land is required for public purpose to expansion of roads and other things.
But it is in his possession.
No, my lords, possession is not here.
Not in his
They are
possession.
claiming that they have encroached. That cannot be the possession.
But you had instituted a PPP proceeding for recovery.
Yes, yes.
And you did not press it further.
My lords, so that after, my lords, what I humbly submit, after the disposal of the writ petition, OJC, the disputes are settled
once for all.
Once for all. There is no cause of action.
Yeah.
Merely making a representation and claiming encroachment doesn't give any rights for consideration, my lord.
Anything to be stated?
Lords, on legitimate expectation, my lord.
That ground you have not taken up in the petition.
In the petition, but it arises out of
Supreme Court says, unless estoppel, res judicata, and legitimate expectation are pleaded, court need not take it.
My lords, the carrying coal to Newcastle, my lord, the law is that in a given set of circumstances, a court may expect an administrative authority not to act judicially, but to act fairly. That, my lord, I'll just rest on that pedestal, my lord. So far as the other aspect of acquiescence is concerned, my lord, in the judgment I passed in the morning, the Supreme Court categorically says,
what is acquiesced here?
My user of the land is acquiesced to. And
where have you taken up that contention for them to meet?
The petition, my lord, stands on the premise that the previous judgment of this honorable court laid down the framework within which the land to be allotted to me, my hitherto trespass or my hitherto encroachment to be regularized on the payment of premium, relying on the 1972 letter where he says that a decision has been taken by the government, no less, that the land is to be settled to. I am seeking enforcement. I am seeking non-retraction, or as the Honorable High Court at the Division Bench says, resuscitation of that assurance that is given to me. That is my entire case.
Yes.
The facts, my lords, apart from minor push and pull, do not appear to be disputed at all by my learned friend appearing for the state. I have in several representations, including the ones that I placed before your lordship in the morning, demonstrated that I have at the earliest disclosed that I was in encroachment of about half an acre of land, that I was constrained to do so, that I am willing to pay for it. And the Honorable High Court in its previous judgment records that I have encroached about 0.53 acres of land.
No, 1957.
1957 is as per their proposal what is to be regularized. Yeah. The High Court's judgment, my lord, specifically records.
But it would have granted for entire encroachment.
No, what happens is they give a commercial proposal only with respect to the 1965.
Where have you retained the liberty to, in that judgment, where is the liberty given to you to agitate for rest of the land?
No, there is no express. There is no
all contentions have been taken up in that.
All contentions have been taken up.
And judgment has been read.
The principle is laid down judgment is rendered, and I therefore ask for implementation of the principle recognized by the Honorable Court.
No, or in operative portion of the order.
Certainly, not in the operative portion of the order. Not in the operative portion of the order. But at the same time, there is the High Court does not say that, well, it is beyond the power of the state or beyond the list to regularize anything beyond 1965 square feet. And when he does not act on my representation, I come back before this Honorable Court as early as 2004. The writ petition, my lords, surprising as it sounds, is from 2004.
Yes.
In fact, my lord, this Honorable Court, number of other courts have recognized that a second writ petition to implement the benefit granted by a previous writ petition is maintainable.
That benefit is granted to you.
The specific benefit is granted. The 1960. Why is the 0.456 acres any different, my lords, from is the question I ask myself.
No, that you should have argued before the division benches, or you should have taken the matter to the Supreme Court. I'm saying, when I have encroached so much of land, why the High Court should confine it to 1957 square feet? As they have challenged. You also should have challenged that. Otherwise, the doctrine of res judicata operates that way. The object of doctrine, whether judgment is wrong, right? We are not the 92 Supreme Court, which which is that famous judgment. I forgot that judgment of famous English judges quoted by Wade and Forsyth, their administrative law, which Apex Court mentioned in AR 1992. Take note, that judgment 1992.
Quinn was
no 1992 SC 111. Go to para 5 or 6 of that judgment where they have quoted some Singh, I don't remember, some Singh versus State of Punjab. Take out that judge 1992 Supreme Court, page 111, para 5 and 6. Gurudev Singh, you're right. Just learned counsel may look into that. There it is reflected. It's not reflected. Yes, I will show that. Yes, they say in the instant case, the response by dismissed from service may be illegal. The order of dismissal has clearly infringed their right to continue in the service, and indeed they were precluded from attending the office from the date of their dismissal. They have not been paid their salary, etc. They came forward to the court with a grievance that this dismissal from service was no dismissal in law. According to them, the order of dismissal was illegal, non-operative, and not binding on them. They wanted the court to declare that the dismissal was void and inoperative and not binding on them, and they continue to be in service. For the purpose of these cases, we may assume that the order of dismissal was void, inoperative, ultra-virus, and not voidable. If an act is void or ultra-virus, it is enough for the court to declare it so, and it collapses automatically. It need not be set aside. The aggrieved party can simply seek a declaration that it is void and not binding. But nonetheless, the impugned dismissal order has at least a de facto operation unless and until it is declared to be void or declared to be null by a competent body or court. In Smith versus so and so, this is the Lord Radcliffe observed, an order, even if not made in good faith, is still an accepted is capable of legal consequences. It bears no brand of invalidity upon its forehead, unless the necessary proceedings are taken at law to establish the cause of invalidity and to get it quashed or otherwise upset. It will remain as effective for its ostensible purpose as the most impeccable of orders. Apropos to this principle, Professor Wade states the principle must be equally true even where the brand of invalidity is plainly visible, for there also the order can effectively be resisted in law only by obtaining a decision in appeal against the said order. The truth of the matter is that the court will invalidate that only if the right remedy is sought by the right person in right proceedings and circumstances. The order may be hypothetically nullity or wrong, but court may refuse to quash it because of plaintiff's lack of standing, because he does not deserve a discretionary remedy, because he has waived his rights, or for some other legal reasons. In any such case, the void order or a wrong order remains effective as if in reality it is valid. Now, all contentions you had taken up, including the extent of the alleged encroachment.
Admitted encroachment.
It is discussed by the division bench. Lastly, division bench said that you are entitled to 1957 square feet. Now, how can you maintain another writ petition when you are faced with the order under which you have derived the benefit? You have derived the benefit under that judgment. No liberty is reserved under that judgment to agitate for rest of the encroached area. That is where the doctrine of res judicata plays.
What's the submission is as follows. The court recognizes encroachments, lays down the principle on which it is to be regularized, considers the proposal initiated by the government, and directs implementation of that without excluding my right, my lords, to apply the principle to any other land that I may have.
That liberty is not
the liberty is not there. The liberty is not there.
So the order is concrete. Para 9 is concrete. Para 25 where contentions are considered.
Yes.
Encroachment, etc., etc. I may not agree with the judgment because the judgment gives premium on illegality. But there is a judgment. That benefit you are entitled to retain. Rest of the benefits are excluded.
What happens, my lord, to the policy of 1972, the decision of 1972 communicated to me?
That goes because that merges into the judgment of the division bench.
And the and the abandonment of the proceedings in 2006.
That all that merges into it is subsumed by the judgment.
2006 is subsequent to that.
No, 2006 all. That makes no sense because there is another point of rule of law which a division bench has not considered. Admittedly, your prayer says you are an encroacher.
Yes.
How can an encroacher? You are not supposed to encroach the land, more particularly public land. Why should the encroacher be given the kick?
The encroacher has by continued user, occupation, payment of taxes, and inaction of the state, and willingness to comply.
No, there is no willingness to comply with them at all. There is nothing.
My lords, would your lordships, the memo that I filed today, would your lordships just take a letter, look at the final order in the OPP proceedings?
That is dropped.
That is dropped.
For non-prosecution.
Yes.
That does not. Rajasthan High Court has taken the view under the Rajasthan Public Premises Eviction Act that once these proceedings are dropped, that does not make the occupation regular. Because the unauthorized occupation is very widely interpreted by the Apex Court in 1978 Supreme Court. Very widely. They gave land to you to establish an industry.
Yes.
You are happy with that.
Yes.
Then somehow you encroached the land. They said part of encroachment will give you, rightly or wrongly. They gave it to you. You entered into a concluded conveyance, where also you have not retained any right to say, I will put my signature to this conveyance, reserving my right to fight for the rest of the land. That is not your case. That liberty is not reserved even in the judgment, DB judgment either.
Kindly see, my lord, page 69.
69. What it says?
This is my representation made before filing this writ, my lord.
Before filing the writ?
This writ.
Correct.
And at page 70, towards the bottom, about halfway through, I cite the 1972 communication, etc. And then I say at through page 70 that since I represented to the government for reduction of the penal rate and settled the land as per usual existing rate, claiming parity, that is, the government not being satisfied with my such representation issued me a notice for determining plot 25A, measuring half an acre by the letter dated so-and-so. By another letter dated so-and-so, government was pleased to determine the and direct removal structures, etc. Finding no other alternative, I approached the Hon'Ble High Court in so-and-so for natural justice. The state government in the counter aforesaid to the writ petition admitted that as allotted plot 25A measuring half an acre of land. It was first submitted by the state government that I had unauthorized encroachment of, it should, instead of 434, it should be 536 of land in eastern side. After considering all amendments, the Hon'Ble High Court decided the writ and it says suit and passed the following judgment in para so-and-so. From the impugned decision extracted above, it may be seen that the foundation for determining the lease and encroachment of land made by the petitioner. There is no dispute that the government at one point of time directed to settle the encroached area with him on payment of premium penalty, but because of unwillingness shown by the petitioner to make payment of penalty as directed by the government, final outcome could not come through. Then my affidavit is cited, and then, my lords, the operative portion. Therefore, my lords, towards the end, after extracting again the Hon'Ble High Court's judgment and the specific finding that eviction from the demised plot as well as from the encroached area is not in public interest. This I'll show your lordships in the morning.
The encroached area is mentioned as 1957.
That 1956 calculation comes after this one. The finding comes first.
Correct. But otherwise they would have given the judgment for whole of the area. Going by your logic.
Yes.
The court should have handed the judgment for comprising entire area. It did not. It was a kind of the court, I feel erred. I cannot say as a single judge I am bound by the judgment. I may disagree, but I cannot defy. Therefore,
can you see the next paragraph? That it is respectfully submitted that though the encroached land located to the backside of the allotted plot number so-and-so has not been settled in my favor, and since I have made constructions over the backside encroached portion adjacent to plot 825 and more than 3 decades have elapsed, and that at one point in time government was pleased to settle the entire encroached area on payment of premium along with penalty, the said order should be considered in the ends of equity and justice, and therefore honestly request to settle the entire encroached area adjacent to so-and-so.
Where is equity and justice for an encroacher? One who is encroaching my land, can he plead equity and justice?
Fairness, man. That is the only fairness. Maybe not equity, but uniform application to. If the state has stood by and allowed me to construct after me having disclosed that I'm in encroachment, that my lord will operate against the state. And that is what the Supreme Court says.
Nothing.
Paragraph 39. That's the judgment I had handed in the morning. Chairman, State Bank of India.
The service matter.
Service matter.
Para
39.
Before proceeding
further, it is important to clarify the distinction between acquiescence and delay and laches. Doctrine of acquiescence is an equitable doctrine which applies when a party having a right stands by and sees another dealing in a manner inconsistent with that right, while the act is in progress and after violation is completed, which conduct reflects his assent or accord. He cannot afterwards complain. In literal sense, the term acquiescence means silent assent, tacit consent, concurrence, or acceptance, which denotes conduct that is evidence of an intention of a party to abandon an equitable right, and also to denote conduct from which another party will be justified and by inferring such an intention. Acquiescence can either be direct with full knowledge and express approbation, or indirect where a person having the right to set aside action stands by and sees another dealing in a manner inconsistent with the right in spite of infringement, takes no action mirroring acceptance. However, acquiescence will not apply if lapse of time is. And then on the other hand, acquiescence implies, at para 40 in the middle, on the other hand, acquiescence implies active assent and is based upon the rule of estoppel in fine as a form of estoppel. It bars party afterwards from complaining of violation of right. Even indirect acquiescence implies almost active consent, which is not to be inferred by mere silence or inaction, which is involved in laches. Acquiescence in the matter is quite distinct from delay. Acquiescence virtually destroys the right of the person. So therefore, my lord, this is a case where the
applies to you. Acquiescence applies to you because you took the benefit under the order of the division bench.
And I came back to court.
Now that once you are having acquiescence with the grant by virtue of the supplementary lease, this judgment goes against you and it supports that.
My lord. In fact, my lords, I'm in this before this court in implementation of the finding and rationale of the court prior judgment. Okay.
Then, petition dismissed on the following grounds. 1. An encroacher has no right ordinarily to invoke writ jurisdiction, more particularly when he had been benefited by the division bench judgment, kindly be seated, judgment, pursuant to which he consciously put his signature to the said deed, agreeing to take an area, encroached area of 1957 or 59, what is 65, 55 square feet. First off, therefore, the ruling cited by learned counsel appearing for the petitioner in 2022 SCC 301, more particularly paragraphs 39 and 40, far from aiding his client's case, would come to the rescue of the respondents. Next one. Either in the division bench judgment or in the lease, supplementary lease, the right to seek the allotment of other part of encroached land has not been retained. First off, the vehement contention of counsel for the petitioner that earlier they had agreed to allot entire encroached area, nearly about half an acre, subject to paying 10 times the premium. And therefore, now they are stopped from contending to the contrary, does not avail to the petitioner, since that aspect has been subsumed in the division bench judgment, since that has been specifically discussed therein. First, next paragraph. Petitioner has been duly allotted a particular piece of land, and thereafter, very strangely, has been allotted a part of the encroached area, even though there is no such provision brought to the notice of this court for allotment of encroached, as rightly contended by learned PGA Mr. Behar. This court is not very sure that power to allot land would extend to allotting encroached land itself. First, an argument to the contrary would amount to a principle that would allow placing premium on illegality. Next paragraph. The vehement contention that petitioner has having encroached the land adjoining the allotted land, and therefore he has perfected his title by adverse possession, is difficult to agree with. Of course, though this contention has been pleaded in the petition, has not been much urged before the court, and therefore the same pales into insignificance. Next one. The encroacher of land cannot plead equity and justice on the ground that he has been in encroachment for a very long time and that he has developed the encroached land, and further that he is paying the taxes for the same. First, he does it at his risk. First, when encroachment is to be removed, all development also would go to the landowner. Is the rule. Is the rule. Subject to all just exceptions, into which argued case of the petitioner does not fit. Next paragraph. The contention that the proceedings for, under the provisions of OPP Act were instituted and thereafter the same came to be dropped would not make the encroachment a case of non-encroachment, to say the least. First, no provision of law is drawn to the notice of court which provides for regularization of encroachment, unlike in the cases of agricultural lands, the case of agrarian lands. Agrarian lands. First time. Next paragraph. All other contentions that have been advanced this day are liable to be res judicated, either by way of doctrine of res judicata stricto sensu, or the doctrine of constructive res judicata enacted in amended section 11 of CPC 1908, which is held to be applicable to the writ proceedings as well. First one. Next paragraph. The nuanced submission of counsel for the petitioner that the division bench had laid down the principles on which case of the petitioner should be considered, and therefore the representation has been made by him subsequent to decision of the division bench is bit difficult to countenance. First, all rights, interests, and obligations have been put in concrete shape by the division bench by virtue of its observations in the operative portion of the order at the para 9 of the judgment, which reads as it. Course reluctantly made this. Okay. But one thing I should say, very beautifully you have argued the matter. very beautifully. It was tough for me to deny relief to you, going by the intellectual height and merits of your argument. But I felt that this is my judgment. Anyway, thank you so much. Yes.
Password item 26.
Yeah. Not that. Such arguments are rarely advanced in this bar. Very rarely advanced in either English quality or legal quality. Yes.
The Rahulkala Development Authority that had allotted the one MIG house and 55 in name of my father. In the name of my father. My father expired.
Order impugn. What is the order impugn?
That's in the Annexure 6. The
Page number?
Page number, Millard. 29. The secretary once allowed my application. Because I filed a representation for early disposal of the mutation property in my name.
In your name?
Yes.
How it was in the name of whom? First
name of it was in the name of my father.
Father's name is?
Father is Kshamanidhi Das.
The first time it has come, or
it is the first time has come.
First time.
Take notice.
Millard.
Therefore, all names will be entered in the record of right.
In the legal heirs.
Why only your name?
In fact, I have applied for a mutation with consent of my all legal heirs of the deceased father.
They have consented to?
Yes.
You have made them party here.
The legal heirs have not been made as party.
Then how to ascertain whether they have consented or not? You will say one line in your petition. They may not know.
But once allowed by application, the secretary, the Rahulkala Development Authority, under Annexure 3, you also kindly glance.
Had allowed.
Yes, allowed by
After it
application.
is cancelled.
Allowed, subsequently cancelled.
Correct it is. Because you are not the only son. There are other children.
We have my father died leaving behind 3 sons and 5 daughters.
Correct.
Out of which one daughter is residing at London.
Let her live in London. How she will lose the property?
No, they have not contesting the matter.
Question is not that. Succession of property is by operation of law. Whether even if they go to moon, they will have a share in that.
That is, I don't dispute on the same.
You take notice. Let us see. No case actually. Anyway, I don't want to dismiss now. Yes.
Also, the
requested to accept notice for 1 and 2. You implead all the legal acts of the deceased father.
In order to ascertain the same, they have issued this notice for their appearance. And the morning, my lord says.
Everything has been done in video conferencing mode.
Very well.
The hearing was conducted.
Yes.
It was allowed. Subsequently, because I filed a representation for early disposal, that was cancelled.
Correct, they have done. Suppose only if your name is entered, you sell the property and pocket entire money. What happened to rest of
others have consented?
Where is that? You are saying that. Where are the
I will impede them party.
Petitioner to Elders of deceased
Kshamanidhi Das. Kshamanidhi Das.
So and so. Within 2 weeks. By making appropriate application. Okay. Yes.
Item 38.
Yes. CMAP.
My lords, this is for restoration. There is delay.
How many days delay?
It is almost a year. The private parties are there. Notice will go.
Issue emergent notice. Returnable in 4 weeks. Yes.
Item 39.
Both on application and both application and IA.
Three notice will go to 3.
3. Notice will go to 3.
I can take notice.
You can take for 1 and 2. 1 and 2. notice to the private party, because delay I cannot condone without hearing the other party.
Delay is due to my knee replacement.
Correct, I agree. But party
for my delay, the party should not suffer.
That notice go. After notice, we will condone the delay. Notice has to go, because Supreme Court said you cannot condone delay without hearing the other side. There is a cause for condonation, I agree. But let notice go formally. You take notice. Okay. Issue emergency notice to 3. Yes. Returnable within 3 weeks. Next.
Item 39. My lord, before I take your lordship's kinds consideration to the impugned order, the facts of the case is like this one. The present petitioners before your lordship filed one title suit. The prayer in the title suit was...
Title suit is OS number or is
it? OS number 89/410 of 2006/1995.
89 of 95.
89 of 95, which was renumbered as 410 of 2006. There in the suit, this is between the family members who do one mudra seva in Lord Jagannath temple.
Mudra seva.
Mudra seva.
What is meant by that?
Mudra seva, my lord, it is a one type of rituals of Lord Jagannath that when my senior is from that area, he can say.
The mudra seva is that every day, that night, Jagannath Mandir is locked. Then a seal is affixed.
Mudra, seal.
Seal.
Okay.
That at the time of closure and at the time of opening, those Sevites has to remain present, those who do this. That is called mudra.
That putting mudra, it is mudra seva is not a ritual. It is not associated with the temple. It is only protection of the deity.
No, my lord, there are different sevas.
It is that is servitors of Lord Jagannath. It is there is a record of rights. In the record of rights, who will do what
is mentioned.
Oh. That is, they are all called Sevites.
Shavites.
And everything is called a service. That is,
there are different types of services of Lord Jagannath.
How the service that cook who prepares is called swara. Like that.
This is one.
This is one.
This is one.
There are near about 30. Previously it was 3,600 sevas, and now how many is there? I cannot say.
My senior is from that area. He knows much better.
No.
My lord, what happened? There was a dispute.
When you said mudra seva,
yes,
what came to my mind is mudra rakshasa. The mistakes in the print. In fact, Mudra Rakshasa is also a novel in Sanskrit. I don't know, maybe Shudraka Kavi, something like that. Anyway.
There is a dispute between the family that who will do that seva. A suit was filed for permanent injunction with other ancillary reliefs.
Who is your opponent?
My senior.
Okay. You are ready in the matter?
Yes.
Once I hear, I will not give time. That's the reason I have stopped giving time.
Yes. No, I will not take time.
It's a very small matter.
What happened to suit?
Yes, suit is pending.
Pending.
Yes.
What is the prayer in the suit?
Suit prayer, your lordship may kindly turn to page 3 of the restriction.
Page 3.
Yes. These are the reliefs. My lord?
Read.
Yes. Let the title of the plaintiff over Mudra Seva Pali in Jagannath temple in the entire months be declared and their possession thereon be confirmed. Let a decree of permanent injunction be passed against the defendant, prohibiting him from interfering in the Mudra Seva Pali of the plaintiff in the temple of Lord Jagannath.
These are two. One is?
For declaration?
That you have that right.
Yes. That right is not in dispute.
But why do you have made the prayer now?
My lord, why have I wanted the lordship may kindly tell
Any
me.
issue is framed.
Yes. No issue.
That hearing is concluded.
Sir, let me. It will affect that suit. That's why I'm there.
The judgment is awaited.
Sir, I cannot match my senior's acumen, but I'm trying my best to address your lordship. My lord, thereafter, a dispute is there whether this private opposite party is the actually legal heir to have that Sevapali, because there is a dispute in the family that who will hold the Sevapali. That is also an issue in another suit. That is also this opposite party filed one suit, that is 94 of 2011, saying that I am entitled to get a portion of the Sevapali. I said it should be for entire month to me. They said no, a portion has to be given to me.
That is money.
No, this is a Seva in lieu, they get certain money.
No.
They get certain offerings which is offered to the Lord, and with some amount of remuneration from the temple authorities. Then
two suits are pending now.
Three suits are.
One more suit is.
Yes, one more suit.
By whom? That is, say, one is 89 of 95.
Yes.
Another is 94 of 2000.
OP number 2 filed suit 94 of 11. And another suit, my lord, that is there between
Number,
my lord, at the moment, I don't have the number, but there are three suits, my lord, admittedly. During pendency of the suit.
Yes, 824 of 2014.
Yes, sir. Correct. My lord, in that suit, the dispute, in my suit, there 824.
81 of 2004.
81 of 2004.
There is 824 of 2014 also.
Yes, that was disposed of.
That is disposed of.
Yes.
Now what is pending is 81 of 2014.
Yes. 81 of no. My lord, 81 of
2004.
81 of 2004.
Yes.
89 of 14.
89 of 14. And
89 of 95.
94 of 2011. I'm sorry. 89 of 1995. And another suit.
Another is what?
81 of 2004. In their suit, that is, my lord, 94 of 2011, I have raised a point in the written statement that he being not a legal heir, a natural born son, he is not entitled to any Sevapali. Opposite party number 2.
In that suit, you have raised this issue.
Raised this issue.
Whether any issue has been framed?
Yes, issue has been framed. And evidence has been recorded. Now it is hearing has been completed. What happened, my lord? During this pendency of the suit, once I have raised that point, a application under section 13 of the Birth and Death Registration Act was filed.
Application 13 after 1 year of birth.
Yes, that your lordship may kindly see.
That is magistrate power to record the registration.
This act came in 1969.
Correct.
My lord may kindly turn to their application. Their application is under
section
Annexure 3, page 49.
Yeah.
With your lordship's permission, may I place that?
Yeah. When was he born?
Yes.
Before the act came into force or after?
Yes, before 1960.
1960. Then also there was an act.
There was a
Section of Birth, Deaths and Marriages Act 1800 so and so.
1886.
1886 was there.
Yes.
So how that's going to come to your rescue?
My lord, I'm coming to. He filed an application that a certificate may be given to me. A certificate may be given to me.
Yeah.
May I read the prayer, my lord? Your lordship may kindly turn to page 49, paragraph 2. That one late Radhamani Mudra was the mother of the petitioner and late Jagannath Mudra was the father of the petitioner. Out of their wedlock, the petitioner was born on 23/3 to 1960. 21st March 1960 at the residence such and such.
Anyway, he seeks a registration of his birth. That is his prayer.
Yes.
Yeah.
The learned authority, my lord, directed for registration of birth certificate.
Correct.
My first point before your lordship is Your Lordship may kindly see section 13 for a moment. Delayed registration of birth and deaths. Any birth or death on which information is given to the registrar after the expiry of the period specified thereof, but within 30 days of its occurrence shall be registered on payment of such late fee as may be prescribed. But within 30 days from the date of it. Then any birth or death of which delayed information is given to the registrar after 30 days, but within 1 year of its occurrence, shall be registered only with the permission of the prescribed authority and on payment of such and such.
Correct.
Any birth and death which is not registered within 1 year of court shall be registered by the magistrate of the first class or the presidency magistrate after verifying the correctness of the birth and death on payment of prescribed fees.
Yeah.
Now, here there is three catch. First,
First 30 days, I have read all those days.
Yes.
First 30 days with the authority.
Yes.
With the fine. Then up to 1 year with the other authority, up to particular fine.
Yes.
If it is beyond 1 year, magistrate order is required. This is what Madras High Court has said.
Yes.
Now, what is that you want to say?
This application was made during pendency of the suit, which was where an issue regarding the birth of the child or the parentage of the child or the legal heirship of that person is under challenge in suit.
Very good.
Once this is done, my lord, this document was produced in the court in the cross-examination that I have got a certificate to justify that I am son of such and such.
It is not conclusive.
Yes. My entire endeavor before your lordship is that once this certificate is there, any document which is post facto the filing of the suit and the claim registered, this should not have been considered at all, and this will be decided ultimately in the evidences in the suit, because this certificate cannot be taken into consideration once the suit regarding the sonship is
which section says the certificate issued by this is conclusive?
No, I'm not saying conclusive. This is being used in that suit. That is the reason I came out.
You lead evidence saying that the registration of the certificate cannot be used because of other evidentiary material.
Manab, that much only I want. That can be that it will be ultimately decided in the suit.
Now suit is pending. Why should interfere?
No. Now this order is staring at me, Manab.
Which order?
This order granting him certificate.
That will not come in. The court will treat that also, whether it should be acted upon or not, because there is no provision. Madras High Court has said, Allahabad High Court has said that the certificates, contents of the certificates are not conclusive.
Manoj, that much I want.
Such a section.
Manoj, unless I challenge this order, in the suit I cannot raise. So I challenge this order.
Why he cannot raise that point in the suit?
You can raise that.
Manoj, that may be recorded and
why it should be the
petition prayer is.
Any observation made
petition prayer is.
I am only praying that much only.
Any objection made by this court may either way influence the court. I am not.
No, I am not observing. I will say it is open to the court, open to him to argue on the validity of this certificate.
Anyway, this certificate will never be conclusive.
That's what. That's what.
But there is an order. Manoj, unless I challenge this order.
I will not give you more time. These are all 2 minutes cases. Rest of the lawyers are waiting. For this, if you take whole day, where they should go?
No.
Only 2. In my right, 86 Supreme Court said we should fix a time limit for argument.
Absolutely.
Otherwise, whole day you will argue on silly matters.
No, man. I leave it to
These questions ought not to have been disposed of at the stage of the admission itself.
Shorn
6 years. Yes.
All right, kindly be seated. Shorn of pleadings and the arguments done extenso in this court, kindly be seated. The short grievance of the petitioner is as to the alleged authenticity of a registration of birth certificate. First off, counsel for the petitioner submits that an issue relating to birth of a particular person having been raised in a pending suit, the certificate is likely to prejudice his case. Yes. First off, this is absolutely misconceived. in as much as the certificate of the kind is neither declared to be conclusive nor declared to be highly presumptively valid. First, the court below will take its call on the subject issue, keeping in view all the relevant and admissible evidentiary material, including the certificate in question. First, in the above circumstances and with the above observation, petition is disposed. Yes, hereafter I am fixing the time limit for argument. You cannot go on arguing the matter in extenso.
Unless it is a very complicated.
Very complicated. 86 Supreme Court said court should fix time. 1986 Escorts Limited versus so and so. It said justice take out that judgment. 86 Supreme Court. Court said it is high time that courts will fix time for argument. Otherwise, all irrelevant arguments, extenso arguments on everything, and we cannot decide the matters at all. Important matters.
My lord, why I filed a writ? Because an appeal is barred. That's the reason I filed a writ. That is, my lord, 119, volume 2000, volume 119, 2015 CLT 1051.
Appeal against what?
This order is not appealable.
No, that order, sir, it is one of the pieces of evidence.
Yes.
Where you can show it cannot be acted upon because there is no provision. Madras High Court and Allahabad High Court have taken this view. Therefore, I expect lawyers to be up to date. All judgments, all laws, all literature, history, philosophy, sociology, everything you should read. That makes no sense.
No, I brought this judgment because the maintainability of the writ can be raised by the other side. That's the reason I brought this judgment.
Next.
Item 40. Urgent copy of your lordship.
Today only. Yeah.
Item 40.
The whole matter, I'm for the housing board.
Yes.
I think one instruction, if I may be permitted 7 days time, I will get one instruction and one notification that will suffice.
2 weeks at the request of so very reluctantly adjournment granted in this whole matter. Next.
Item 40.
2017. It will come after 2 weeks. Yes. Next.
Item 41, 42 have been adjourned. Item 43.
Yeah. Yes, sister. 43.
Today we are filing counter in this case. In one of the cases we are filing. Other cases we shall file, my lord. We are preparing it.
2 weeks for filing the counter.
In all cases, yes.
In all cases. You file in the registry because what all mistakes are done, we do not know. Applications are filed without stamp also.
Yes, we shall file it in the registry as well as the filing will.
Okay.
He may be given a copy.
Yes,
kindly give copy.
Yes, yes.
Okay.
Item 44. Item 44.
Check covered judgment. Covered by covered by judgment.
Yes.
There are two decisions. That's the time it is getting confused.
One is Mishra.
Have you corrected it?
With effect from the date of entry.
Date of entry.
Date of entry.
Notional benefit.
Same order.
Same order. They got a better benefit.
G, covered by judgment.
Yes, yes.
They are getting a good benefit.
Item 45.
Yes.
My lord, previously was working as a mobility teacher in the handicapped school, my lord. He got the grant in aid from 2009 to up to 2015. But the 2015, they asked if the certificate not sufficient.
What pays for the other?
His salary was stopped from 2015, madam. From April 2015, his salary, the grant which was receiving from 2009, that was stopped. And the reason?
What's your prayer?
the reason is, my lord, now sufficient certificate was not given. If the sufficient, what is the sufficient certificate? I don't know. I have given all the certificates that were verified. After verification, notification was done. These teachers are going to be appointed. If any objection are invited.
Kindly go to 10-10-23 order.
My lord, 23, your lordship. 23, my lord. Page 76, my lord. That is.
So, G, are you ready in the matter?
Yes. They have admitted. They have admitted.
What it says?
They say, whereas the petition was working at the post of the second line, my lord, the previous interpretation direction was given to dispose of the.
My lord, we shall file a counter.
Whereas
draft counter is ready, please. Draft
You want
counter.
to file counter?
We shall file a counter.
File counter in 2 weeks.
Are you lordship, please? Yes.
For filing counter. Filing petition application of with face value. Next.
4/6/2004 4 weeks time given.
No, this is last time. This is last
2024. 4 copies have been supplied. 4 weeks. Thereafter, 5 days of the 4 weeks.
Next.
My lord.
Item 46.
The petitioner will receive a retired employee.
There also counter is required.
Counter in 2 weeks.
This is a covered matters.
Item 47.
Item 47. My lords, I am appearing for the petitioner. Petitioner is a 74 years widow.
Lordship may dispose of this matter, entitling him to receive family pension, basing on Subhana Divya's case.
Covered by the judgment.
Yes.
Can you furnish that copy?
This is another copy, my lord, I am having, but this is their lordship have disposed of.
My lords may just observe that pension would be granted based upon the rules prevalent at the date of superannuation.
The petition prayer reads as under. The subject matter of this petition is substantially similar to the one treated by a coordinate bench of this court in WPC 22660 of 2016 between Subhashini Patnaik versus State of Orissa, disposed of on when it is on 26/4/2023. At the para 12 of the said decision, it is observed as under. Next paragraph. In the above circumstances, this petition, any questioning to be done?
No, my lords.
This petition.
My lords, watching Annexure 10, my lords, sorry. Annexure 10. Annexure 10.
Annexure 10 to be questioned.
Yes, my lords.
This petition is allowed. The writ of certiorari issues quashing the impugned order dated 9/7/2024, a copy whereof avails at Annexure 10. First, claim of the petitioner for
family pension.
For family pension has to be considered in the light of the rules that obtained as on the date of superannuation of the employee who died on 1/4/1982. Correct?
No, my lords, died on 17/3/1973.
73.
Yes, my lords. And date of superannuation is 16/12/1993.
73. Date of superannuation, that is
16/12/1999.
16/12/1999. Time for compliance 8 weeks. Now no course.
Item 48.
Yes.
But the petitioner is selected a candidate at the post of junior teacher, Urdu. And Millard, as per the advertisement, the requirement is that he must have passed the HSC in class 10 standard, Millard. And although, Millard, he has possessed the requisite qualification, Millard, but since he has not passed the ODIA, he has already passed the ODIA from Board of Secondary Education, Millard. But Millard, and his serial number is at 1, Millard. So accordingly, verification and scrutinization document already completed, and the school has been allotted to him, Millard. But thereafter, Millard, Annexure 7, Millard.
Annexure 3 may kindly be seen at page 5, page 23. That is the advertisement. Advertisement for guideline for engagement of junior teacher within bracket schematic.
5.2 you have challenged.
5.2. 5.2 is in order to be eligible for Urdu, Bengali, Telugu junior teacher schematic, candidate must have passed Urdu, Bengali, Telugu as the case may be, as MIL. MIL means Mother Indian Language. Mother Indian Language.
Mother Indian Language.
Yes. To high school certificate standard, since their engagement is likely to be held in the bilingual schools, such candidates shall produce a certificate from the headmaster of the concerned school to the effect that
he has passed examination in
ODIA medium.
Yeah.
My lord, here
has he not produced it?
In my case, my lord.
One second.
He has not produced that. He is having Urdu as MIL, but he is to write the Odia script. Odia vernacular.
Urdu to be written in Oriya?
No. Urdu is MIL. He will write that in Urdu language. But other subjects like mathematics, like science, sociology.
Those subjects should be written in Oriya
language. That is the basic requirement of the advertisement.
That he says is bad.
That he says is bad, but that he is not acquiring that qualification.
Therefore, he is challenging it.
Yes.
You are challenging this. Where is your prayer? Go to your prayer.
My prayer for engagement, to issue engagement order in favor of the petitioner as Urdu junior teacher.
No, but where you do not have ODIA?
Yes, my lord. I passed your lordship. Kindly see page 12, my lord. Page 12, my lord.
You have passed.
I have the ODIA, my lord, in class in HS standard, my lord. From Board of Secondary Education, my lord.
You are right. You have
now, my lord, they are required to produce the certificate from the headmaster, my lord.
Headmaster.
But I have completed the HSC, my lord, in West Bengal, my lord, and +2 in Orissa Higher Secondary Education, my lord. And my lord, then city from Board of Secondary Education, Orissa, my lord.
3 certificates you have to bring.
My lord. And I have completed, my lord, OTT from Orissa Secondary Education, my lord.
Then 4.
And now, for the requirement of ODIA as a subject in equivalent to HSC, I have completed from Board of Secondary Education, Orissa, my lord.
Yeah.
Now, as per the clause 5.2, my lord, they required under Annexure 7 that you have produced the certificate from the headmaster, my lord. Because I have completed the HSC from West Bengal, my lord. But there, my lord, there is no ODIA subject, my lord. And from Orissa, my lord, I have completed the ODIA, my lord, as required under the advertisement, my lord.
To satisfy the advertisement,
my lord.
You have to fulfill the criteria of the advertisement.
Criteria is prescribed.
My lord.
That has to be complied with.
My lord, I am complied, my lord. The requirement, my lord, the required, your lords, you can see 5.2. Your lords, you can see the page 22, my lord. Clause C. Candidate must have ODIA as a MIL up to class 10 or pass in ODIA language test equivalent to metric standard conducted or declared as equivalent by the Board of Secondary Education except for the candidate as mentioned under para 5.2.
then your lordship come to para 5.2.
You fit in exception 5.2.
They declared that you must have passed the ODI from Board of Secondary Education.
Yeah.
And I have passed that qualification, my lord.
Where is that?
Page 12, my lord.
Here, secondary
from Board of Secondary Education, Odisha, my lord.
In the month of month, which is equivalent to that of class standard. Knowledge in possesses knowledge in Odia. Yes, sir, Mr. G, he has produced a certificate. Come to page 12. Page 12. He has produced a certificate which says he has knowledge of Odia.
He has knowledge of Odia. I'm not disputing that.
Script.
Vernacular. The script he has not written. That headmaster, he used to get the certificate from the headmaster. He cannot get that because he is from Bengal. He is qualified from Bengal.
So he will not be knowing the script of Odia at all.
No.
That is your case.
Yes.
No, my lord,
he is to furnish that.
I have completed my lord from Odisha, my lord.
It is question is not knowledge of Odia.
And the syllabus is Odia, my lord.
No, the script. You should be able to read and write Odia script.
Odia script.
Where is that?
Because in city, my lord, city training, my lord, the diploma in elementary education, my lord, that syllabus is Odia, my lord. So I
do not know all that.
I have already annexed, my lord.
What is
that syllabus, my lord?
Syllabus is all right. But the certificate is that you know writing and reading Odia.
Because
that certificate.
Is a must, it will be furnished from the headmaster of the school.
The certificate, my lord, which has been issued by page 12, my lord, that clearly, my lord,
this is knowledge. Knowledge, I also have little knowledge of Odia now, having spent almost nearly more than 5-6 months here.
My lord.
That is not sufficient. Because I should know writing.
Yes, my lord. Because the petitioner, my lord, belong to Odisha, my lord. From Kendrapara district, my lord.
You bring certificate.
Well, I have already produced all the certificate.
No, that's not sufficient.
From the headmaster.
It says knowledge of Odia. Because knowledge of Odia includes knowledge of writing, reading Odia. I may speak, but I may not know writing. I may not be able to read at all.
Because, my lord, the diploma in elementary education, my lord, he has right in Odia.
I do not know all that. You have to bring a certificate. They have said you have to bring the certificate. You have not challenged that provision.
I have challenged that, my lord.
Which provision?
The clause 5.2, my lord. Now, my lord, they have already considered me, and I have already selected and placed at serial number 1, my lord.
Correct. But bring the certificate, they will issue the appointment.
And at that time, they didn't say anything, my lord.
No, why 5.2 is there, na?
5.2 is there only. They say that the headmaster has to produce the certificate.
Yes, not headmaster. But you have to produce the certificate procured from the headmaster.
But I have completed the ODI, my lord, from Board of Secondary Education.
You have said it about 10 times now. I have also said it 11 times now. The question is, have you produced the certificate issued with the headmaster?
My lord, in similar issue, my lord, another matter came, my lord, and the one coordinate bench, my lord, already, my lord.
Said like that. Saying that this certificate is sufficient.
Yes, my lord. Para 16, my lord.
Read. What certificate was there before the judge?
It's the same thing, the same clause, my lord. Adopted.
How to assert of that?
Para 16, my lord.
Yes, Mr.
It is relatively
discussed.
Yes. But my contention is, since he is not satisfying the advertisement, he cannot be.
No, that itself we discussed in para 16. Instead of Bengali,
Yes, it is.
that was a Telugu.
Telugu.
Rest of the things completely in line with what he is arguing.
Yes.
He has studied Odia up to 10th standard. Class 10.
My lord.
It has to be allowed.
This is
covered by the judgment.
It is not covered that
Except that candidate was Telugu.
My lord, another judgment I remember that was also rejected by the Honorable Justice Satpathy. I cannot remember the case number, but
Para 16, so many words. Justice Anand Behra has written this judgment.
Miss Misra. Misra.
He writes very good because it makes sense also. See, I was not impressed by his argument first. After reading this, his argument should be understood in the light of observation of the coordinate bench. Otherwise,
my contention is not satisfying the requirements made by the advertisement. That's my disclosure. No problem.
Take now. The essential grievance of the petitioner is against the non-consideration of his candidature for the post of junior. What is that teacher?
Junior teacher schematic.
Junior teacher 2.
Within bracket schematic.
Bracket schematic. In terms of the advertisement dated 10/9/2023, a copy whereof awails at annexure 4 to the petition. Person. Kindly be seated. Basanto, madam. Don't say that I know Oriya based upon this. 3 words I know. Learned counsel for the petitioner submits that in terms of para 5.2, he satisfies the requirement of having the knowledge of Oriya since he has studied in the said medium up to 10th standard. That being the position, the pit court should come to the aid of his client in securing the order of appointment. He presses into service a coordinate bench decision of this court in Purushottama Dalli, DALLI, Purushottama Dalli versus State of Odisha 2025, supplemented to OLR 1014. This is not Mishra Saab's judgment, not this one. Learned AGA Mr. G opposes the petition, contending that no person will have right to appointment unless he satisfies all the prescribed conditions in the notice of advertisement, and that petitioner having not satisfied the same, he is not entitled to any relief at the hands of this court. First. Next one. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter, in as much as the similar question relating to interpretation of paragraph 5.2 of the subject advertisement has been treated by a coordinate bench of this court in the case of in Purushottama Dalli Supra, wherein paragraph 16 reads as follows. Next one. The only difference between the case at hand and the case treated by the coordinate bench is that in that case, the litigant had studied Telugu, and he also studied Odia in HSC up to the level of HSC. First off, therefore, the observations mentioned above would come to the aid of petitioner, and therefore he is entitled to grant of relief at the hands of this court. First off, in the above circumstances, this petition succeeds. Any order to be questioned?
Annexure 7.
A writ of certiorari issues quashing the next
Annexure 7, page number 34.
Quashing the impugned endorsement dated 24/9/2024, a copy whereof awaits that Annexure 7. First, the writ of mandamus issues to consider the candidature of petitioner for the appointments in question within 8 weeks. Should the other conditions be complied, without insisting upon a certificate from the headmaster regarding his passing of HSC examination in Udia medium. No pass. 16, you have to produce that from them. Yeah.
Item 49.
Yes.
Here, the sole grievance is, I was placed under suspension for certain period. That was I was restated.
You were suspended?
Suspended, madam.
What is your prayer?
Here, my lord, that for that particular period, 10/4/2003 to 29/4/2005.
10/4/23.
To 29/4/2005.
About 1 year.
1 year about
suspension period.
That period has been treated as leave under the Odisha leave rules.
Suspension is subsequently revoked.
Revoked.
Any inquiry was held?
Well, to that effect, though they have given the information to me day before, but in that about they have not clarified the. For that I need some.
No, I'll just clarify one thing. Earlier, I was placed under suspension. Pursuant to vigilance inquiry. Vigilance case was set aside. I was acquitted. When the vigilance inquiry was there, I was put under suspension again, and was terminated. That termination was before the tribunal.
Termination was challenged before the
tribunal. And interim order was passed. I continued in service. That case, was finally allowed, and the dismissal, the termination order was set aside. And direction was issued, pay all back wages. In between, after the case was stayed by the tribunal regarding that termination, they again placed me on suspension for that period.
After that termination was set aside?
No, before that. Subsequently, termination was set aside.
Subsequently, it was set aside?
Yes.
That termination included the fact matrix of your suspension also?
Yes. No, but that was not there.
That was not?
No. Subsequently, when this suspension was challenged, this honorable court held that you cannot treat him a suspension like this. It is to be treated as duty for all purposes. With that observation, direction was issued to reconsider for that period.
Very good.
That is Annexure 7. Page 33, madam.
Just 7.
Well, I'm sorry, Annexure 10. Relevant judgment starts from page 33 and the relevant portion of page 34.
34?
Yes, sir.
That was criminal case.
No, this is that period, para 4.2 madam.
That's all right. 4.1 refers to criminal case.
Yes.
Yes, Mr. Mohanty, 4.2 covers his case.
4.2 covers. But so far this proceeding, departmental proceeding is concerned. Further, that instruction I am lacking. But they have treated it as a leave. And in what way, in the segment...
Can leave be forced on an employee? No, why it should be treated as leave?
Well, that is the
An employer
instruction.
cannot force the employee with leave. It cannot be thrust on him.
That period has been
It has to be
regularized as a leave, my lord.
It cannot be. The reasoning of 4.2 will come to his aid. Even if you are holding discipline,
12.6.
where is the disciplinary inquiry? What happened to that inquiry?
In fact, that is the crux of the panel. Whether
No
the
inquiry has been held?
No.
But
With reference to that suspension, my lord, no inquiry.
You are suspending that suspension order.
Suspension order, my lord. Your lordship will get at annexure 5, page 19.
Read.
In pursuance of the instructions of the government, the Department of School and Mass Education communicated by the Director Teacher Education, so by member number so. 9/2003. So Dilip Kumar Pradhan, spinning and weaving instructor of Namakrishna Chowdhury College of Teacher Education, Hon'Ble is placed on the suspension forthwith.
This was a suspension for what purpose?
They have not indicated anything.
No, when the criminal case was instituted?
Criminal case was not much earlier than.
Much earlier?
Yes.
Why he has been suspended?
That is lacking in the instruction manual itself.
No, should they not, whether order should...
For that particular period,
an employee can be kept under, Supreme Court said, an employee can be kept under suspension if he is involved in a criminal case or in contemplation of a disciplinary proceeding or by way of punishment if the rules provide for that one. On what ground you are keeping him suspension? It's a blank order. Even Mughals did not pass such orders. What for you were suspended?
No reason, my lord. Because by that, no. Because the earlier allegation, my lord, was put at rest. My termination was subsequently set aside. Since that period was yes, and that period was intervening period. That's why they have said whatever benefit we have given to you, that also covers this.
Mr. Mohanty, I am imposing cost of rupees 25,000.
Well, let me come with that instruction because Annexure 5 clearly says about 10/4/2003 about the period of suspension.
Correct.
And that period ended in 29/4/2005.
Correct. What did you do? The question is,
why there?
Where is the inquiry?
That I have to ascertain, my lord. From the beginning, my lord, I am saying the instruction what I have, there is a lacking.
This matter for further hearing on in the second week of December 2020. Further hearing.
Yes. And whatever instruction, I have filed it in way of affidavit also.
What I do not understand, no reason is given why he is being suspended. Even East India Company would not have done that. Really. They would have, Robert Clive would have given some reason. You are suspended because your hat is not good or you are not, you did not have correct haircut, etc. Even that is not there.
And surprisingly, when the order of reinstatement was passed, it has been assigned. Page 21, can listen.
Yes. Next. Item 50.
Not second week of December.
Second
week of December.
Yes, second week of December. At the request of Mr. Mohanty.
Second week of December.
Yes.
The 10th of December. 10th of December.
On 10th of December.
Well.
May I please, Your Lordship? My Lords, on behalf of Mr. Nihal Ratha, I seek for some more time to file the rejoinder.
More time to file the rejoinder?
My Lord, on the last occasion, my Lord had given...
Second week of January.
My request. Please, Your Lordship.
51. I'm happy. This is hard down litigation, my Lord. For grant of stripping of pay. Hard down litigation, my Lord. Earlier, the direction issued to recover the amount to reduce the pay and recover. That was passed by my Lord. Again, my second down, the same order passed. Again, my Lord, relying on this coordinate bench, relying on judgment of the division bench, quashed the order. But however, remanded matter take a decision in light of that judgment.
Again, the same fact, my lord. The earlier order is at, my lord, page 54 of this report. Again, the same orders in past.
Counter is necessary, my lord.
While counter is into
3 months only left retirement.
No.
That is the whole problem.
before retirement, you will get them off.
Yes. She may give 2 weeks.
It's my third and retirement. It's a piece of death matter.
One matter, sir, you were saying your client is retiring, 87-year-old.
82 years old.
82-year-old.
It's a picture death matter.
Item 60.
It has come after 2 weeks.
Second week of December. Second week of December.
Third week. Yes.
Fine, okay.
In 92, 95.
He's 87-year-old.
We are not arguing. My senior is not well. In the next item, just he was requesting for accommodation. Yes, well. For his health, he was my friend, senior friend is departed. Not well. For this,
Why have you come to court? You could have sent words with some junior.
I could have given a ring. I could have mentioned for on both the parties.
He is there. When do you want?
Next week.
How you are sure that bacteria will go away within 1 week?
Just now.
Whichever date you want.
1 week after anything.
Yes. Call this matter on 27?
The interim order is there.
Interim order to continue. Yes.
60.
Yes, I can say 63. Yeah. What is this matter about?
This matter, my lord, the petition tribunal in 95 directed to pay the higher pay to the petitioner, my lord.
In OAT order?
OAT order.
Where is that order?
That order I have not very trouble. High Court order I have given, my lord. OAT order confirmed by this court, my lord. In Annexure 1, page 8. And this Hon'Ble Court directed to comply the tribunal's order. That is in 2000. There are 10 petitioners in the High Court order, earlier order, my lord, Annexure 1. All 8 persons have got, my lord. The 2 persons have not got because they had not approached the court. Now file the content petition.
Therefore, now we have filed the petition.
Yes, my lord. The last of
yes, Mr. G. Why everybody should come to the court in contempt once there is an order?
Yes.
Why should not the government honorably comply with the order unnecessarily being hauled up in
Lordship, may kindly have a look to the other annexures.
Yeah.
My brother have annexed.
Yeah.
Lordship, may kindly turn to annexure 4. Annexure 6, your Lordship, may kindly. Annexure 6. Suhas. The inviting
reference to say that directed to say that
his name is not there.
These two. The order of
other content file tango diya gaya.
Others going to 1, 4, 5, 6.
6 persons content file kal tango diya gaya.
They are totally 8 persons. 8%. Why not you other 2 persons?
That I do not have any instruction, my lord. Call this matter next week.
Annexure 2, in Annexure 2.
No, you want
next week.
Short accommodation.
Short adjournment.
I may impose heavy cost of ₹1.
Let me call this matter.
I call it, but I am putting you to the warning. Maybe that the persons to whom they have given, they have bribed them. And they have not bribed, therefore this order has not. OAT order is there, High Court order is there. One more case. How many cases? Man's life is lost in the court hall. Nobody comes to court with happiness. Why he got an order at the hands of the tribunal? Then for implementation, he got an order at the hands of this. That is not implemented. And in respect of others, you have implemented. Why not in respect of the petitioner? No, in this matter I will levy ₹1 lakh cost and they should pay from their pocket. Unless you come with the order on the next day saying that it is complied with.
My lord,
Learned Counsel G seeks a short accommodation to come out with some positive, hopefully fun. First off, prima facie, the denial of relief in the hands of the elementary education director Director Elementary Education appears to be highly arbitrary. And prima facie, the director should be levied exemplary course for driving the petitioner to this court avoidably. First, however, much will not be expressed at this stage. Okay. You show it to the director. I will exempt first, I will extract from him. And I may inflict an injury also on him. This is the kind of, what kind of the treatment the citizens are getting at the hands of officers. Yeah.
But adjourning to next.
Which date you want? Take that day, that day you have to do something.
1 week or 2 weeks after, you may call
this matter on call this matter on 27th. Yes, I may direct the director's personal presence. Yes.
Item 54.
Item number 54. Just now I received the counter affidavit filed by the opposite party number 3.
Calling the second week, December, January 2025.
One more there, Your Lordship. I have filed a corrected cost title, Your Lordship.
Corrected
cost titles.
The corrected cost title filed by the petitioner is accepted.
And there is a noting also. There is also a notice, Lordship, neither AD nor on-sub notice returned from opposite party number 2.
Who is that?
Opposite party number 2 is the Chancellor, Your Lordship, Barampur University.
Chancellor is governor.
Chancellor.
Chancellor is governor under the act.
Under the act, but in the capacity of Chancellor, Your Lordship,
since
already notice has issued.
Acknowledgement, postal acknowledgement, nor the postal cover have returned from us. The office of the Chancellor is presumed to have been served with the notice.
Mobilized.
If letters do not reach the governor's office, what is this? Registry to send a copy of this order by speed post to the office of the Chancellor for information and needful action.
Your item 55, I am for the petitioner. I am for the petitioner, and counter not have been filed by the OP.
Counter not filed. Yes. Counter to be filed, calling the second week of January. Counter may be filed in the meanwhile, calling the second week of January 26. In the meanwhile, counter if any may be filed. Next.
Item 56.
In this case, the petitioner challenges the order under Annex
26. I am the petitioner.
26.
Different matter.
Sister wants to argue your case.
I can wait to take that.
Yes.
May I please take out, Your Lordship?
Yes.
Your Lordship, this is a matter where a provisional order of attachment of the enforcement director was under challenge, Your Lordship. Your Lordship, after hearing the matter...
Similar matter, I did it.
My Lords. I'll just point out few things, Your Lordship. Now, this is a property which was purchased an auction conducted under the OPID Act by the orders of the designated court. So I have brought it in a public auction. Now, Your Lordship had protected me by way of interim orders that they will not pass any coercive orders against me. In the meantime, in violation of that order, they have passed the confirmation order, my Lords, despite Your Lordship's protection and continuance.
Let us.
Have
you passed the order?
No. We have not.
Which order you passed against?
My Lords, I'll just produce an additional affidavit.
Not
against the petitioner.
We have not taken any action against the petition because he is the party to the case. Now he will be included as party.
Whether against the property or passed the order?
Property, yes, man. That's your attachment. That is provisional attachment that has been confirmed by the administrative authority.
Your Lordship has
protected. Section 8 order.
So now he is to approach, my Lord. There is two provisions. First, he can approach to the adjoining authority. And Section 8, that this property is not liable for attachment. It should be released. One. Second, before the
tribunal.
No, before the special court.
Special court.
Yes, 8-7. Section 8-7.
So only recourse, because now it has been confirmed. Now recourse is open under section 87 to approach the session court because we have already filed the complaint case.
Lordship, confirmation despite an order of this court that they will not proceed against my properties bills.
Anyway, now you go before the.
I'll just show something to your Lordship. I've just prepared an additional affidavit to show your Lordship that they themselves, in the confirmation order, have excluded the properties where the titles have changed in the year 2022. That order is there.
You go and mention it.
My Lords,
fix the time also.
Yes, my Lords. Your Lordship may observe that they may consider in the same lines of the findings they have given. And that being there, my Lord.
All contentions I will keep open.
Your Lordship, just one line. One line, if I can show it to your Lordship for a moment, your Lordship.
I'll tell you why in PMLA matters. I have some expertise in PM. Very humbly, I say this as ASG. I have some expertise in these matters. What I suggest is there is a provisional attachment.
Which they have confirmed now.
Which they have confirmed. Now you should approach the designated court. Special court.
Special court.
Special court. You go before the special court. I will direct the special court to take up, consider all your contentions and pass the order.
My Lords, understood me, Your Lordship. Your Lordship is grateful to give us that liberty. We will that. Your Lordship, my additional affidavit, Your Lordship, and just look at one line, Your Lordship. I insist upon that, Your Lordship, for one particular reason, Your Lordship. Lordship, Annexure 12, I'm sorry, my Lords, Annexure 11,
page,
Your Lordship, begins at page number, Your Lordship, 4. And Your Lordship, the relevant part is at page number 7. This something, Your Lordship, I want to bring it to Your Lordship's kind notice, my Lords. Therefore, the aforesaid landed properties having consideration value of so-and-so, fair market value of so-and-so, which were sold to different persons, as mentioned in the above table by Messrs. Vajra Builders and Messrs. Golden Land Developers, are required to be excluded from the provisional order dated 29/4/2025, as the ownership of the said landed properties have changed the year 2022, which is prior to the registration of instance case. Your Lordship, in my case, it is 2018 through a public auction. So the entire list can be brought to an end, Your Lordship. So there is no
this
point.
Is given by whom?
By them. This is their provisional order of attachment. My Lords, the enforcement directorate, Your Lordship. My Lords, the adjudicating authority, Your Lordship.
But he confirmed this also.
My Lords, despite Your Lordship's order.
Brother Subhash Chandra Raut, the petitioner, he has filed this writ application, reputed capacity of RSP Jewelers. But Subhash Chandra Raut is also the director of another company against whom provisional order of attachment. So he has indirectly involved and proceeds of crimes have been utilized by purchasing these properties.
No,
so it is to be subject to adjudication.
1 second. Your recommendation. Kindly read your recommendation. Do not argue contrary to your own recommendation.
I am only submission.
What is that submission? Kindly come to page 7.
Yes, 7 of 5.
Go on harassing the citizens with the PMLA Act. This is your recommendation. And this you act contrary to your own recommendation.
Man, you also know once a provisional order of attachment is passed,
correct.
Within 30 days, complaint is to file.
Against what property? Kindly read that.
Now, once provisional order of attachment is passed, within 30 days, complaint is to be filed before the adjudicating authority. So powerless. Now the director is powerless. That is yours to consider.
No, I am considering it now. Why he should go to the court at all? Right to property is a constitutional guarantee under 300.
Now who will consider his grievance, my lord?
I will consider.
This matter.
Yes,
yes. Then, my lord, then our allegation is that is the provisional order of attachment.
Why can't you bring somebody to control you?
No.
Now, kindly come to page 7.
Of the additional affidavit, page 7.
7, yes.
Yes. Read that recommendation. You can't harass citizens with PMLA weapon.
Therefore, the aforesaid landed properties having the consideration value of rupees 19
lakhs 25,000 fair market value of rupees 1,000, which was sold to different persons as mentioned in the above table by Messrs. Viraj Builders Private Limited and Messrs. Gold Land Developers are required to a student from POA.
Required to be read proper. Pronounce proper.
Order of attachment.
Required to be
required to a student from provisional order of attachment 3/25. Yes.
Yeah.
So now, if on the face of the record, it's proved that there is no use of
So you only said that. Why you should prove? You only have said that.
We have said that in our provisional order of attachment, he is the person. The Subhash Chandra Raut is the person. He is the director of one of the company against whom the provisional order of attachment is passed. That is my view. So that is to subject to
Petition is allowed in view of the recommendation. What decision?
Yes, one. We have prepared decision.
At the base 7, which reads as under. First, to property is constitutionally guaranteed under Article 300 capital A of the Constitution, as has been extensively construed by the Apex Court in 80 plantations for the state of Karnataka. First, the vehement submission of learned counsel for learned senior panel counsel appearing for the ED that the petitioner should go before the designated court under section 8(7) of the PMLA Act is difficult to countenance, in as much as it would be a wasteful exercise to come up. The recommendation itself having exclusion as mentioned above. First of all. Yes, what are the rules you want to rely upon? What for? What is the proposition and what is the ruling?
Well, these are properties. Your losses now posted by the applicant. But these properties, so that this order was passed, this is not related to these properties.
Apparently, the provisional attachment was made before the registration of the case in hand. Is it correct?
No, my lords.
Not correct.
Not correct at all.
After
My lords, I have brought it in a public auction conducted by the ADM.
The subject property has been bought by the petitioner in a public auction held on.
My lords, I'll just point out to your lordship, page number 105, your lordship.
Held on.
Date of opening was 18/10/2009, my lords.
Held on 18/10/2019,
my lords.
2019. Who conducted the auction?
The ADM under a statute.
The additional district magistrate.
Yes, my lords.
The additional district magistrate having conducted the said auction under
the Odisha Protection of Interest of Depositors in Financial Establishments Act 2011. My lords.
First, such properties cannot be roped into the scope of attachment orders. First. What is the prayer you have sought for?
Your lordship, for quashing of the provisional orders of attachment.
In view of the above, this petition succeeds. A writ of certiorari issues quashing the provisional attachment order.
Annexure 1, my lords.
Dated 29/4/2025 to the extent the same relates to the subject property. Petition property.
My lords. I have produced it in a schedule, my lords, which is at page number 15.
Describe the property. Described in
page number 15, schedule.
Property. That is. Just to explain. Page number 15.
My lords. Yes, 1/5 minutes.
1/5. Schedule to be reproduced. All these properties.
All these properties, my lords.
By auction.
By auction, your lordship. Under a recovery statute.
Our stand is that he has purchased the property out of the proceeds of crime. That is our provisional order of attachment.
Right here, only have passed. Yes.
And I have filed the list of decisions.
What for? Proposition you should say.
No.
What is the proposition? What is the decision?
So appreciation of that this Hon'Ble Court should not appreciate the validity of the attachment if on the face of the record there are decision is there, on the face of it there is illegality. That decision, the last decision, last decision, my lord, that is, what are the positions? The first 4 decisions are out of 80 cases. And the last case is year 2024 SC 1893, that is para 29.
The decision cited by the senior panel counsel in PHR Invent Education Society versus Luco Bank 2024
para 29 man.
AR 2024 SC 1893 to the effect that ordinarily this court should not judge validity of attachment orders is not applicable to this case in as much as the authorities themselves have excluded the subject property from the proposal for provisional attachment. Okay.
We're grateful, Your Lordship. One. The property which has been already excluded, those properties are not these properties.
They have set a deadline, my lords.
But he has only cited a order, man. Cited an order. But these properties are not excluded.
Which properties are excluded?
Those properties are relying upon by the petitioner now. Those properties are not excluded.
Which are the properties excluded then?
Those are other properties, madam.
Not these properties?
No, not.
Show that.
Yes, ma'am. That I will convince, madam.
Show that.
By tomorrow, madam.
No. I can't. I don't do cases on installment.
Properties are, khata number, plot number, all these are there.
All they are there.
They will sign it.
How long?
One statement I will file tomorrow. What are the excluded and what are the properties of the petitioner?
You take up the matter in appeal with that contention.
No, only by service.